of a high in criminal.
If your lordship allows, there is a judgment will be delivered in court for, I'll just come.
I'm also in the matter.
Repeat your lordship. For listening or hearing lordship.
May I please your lordship? Your lordship, item number 18 of daily list. We were about to file additional affidavit on assets and liabilities, but the engaged counsel is suffering from eye flu, so we would like to take adjournment for 1 week.
Lordship, I'm appearing for respondent number 2, Lordship.
You have informed the other side?
Yes,
I'm for the respondent number 2, Lordship.
Okay. Both sides are duly represented on the prayer made by learned counsel for the petitioner. List after 2 weeks.
Lordship, may kindly fix it 31st of August. They're seeking for 1 week, so 31st of August, Lordship.
First, 31st. Okay. Yes.
obliged.
Supplementary evidence, item number 19 for August.
Your Lordship, I'm seeking a pass over your Lordship. My
Okay.
seniors large.
Okay.
Even the. Thank you. Lord.
Failure of these council call for them.
My lord, in this series, my lord, with all respect, we submit, there are 2-3 sets of lawyers, my lord. Today, I have some real problems, my lord. So I pray, my lord, that it may, for my part, may kindly be taken up on Monday. I will do it.
We don't know we're not sure about the bench.
Or-
Because that's why.
Otherwise, I'm
It's not a regular
prepared,
bench. It's not a regular bench.
Yeah.
So we don't know.
Oh,
Yeah.
yes. But if it can be accommodated, that way, my lord, I will admit.
No, what we can do is that we can start hearing the other matters and this matter will be John.
How much? That can be done.
Matter.
Because it's a double murder case and juvenile is also involved.
Huh.
That's why.
Well, effectively, it can't be segregated. That's what you
No,
are
no,
saying.
no, definitely. No, my contention is that, my lord, let the appeal, I'm not stopping it. I will do it, but only accommodation till Monday, my lord. If others are ready to do it, Mr. Nizamuddin appears, Nazimuddin. sorry. Nazimuddin is appearing in a.
No, you are fully aware whether he is prepared or not.
Same case, my lord.
Okay.
Ma'am. Monday to-
Yes, you are ready to do it.
No, my lord, Monday along with my senior.
So
But
you-
actually,
Analog
it's a
with
bit
Pata.
complicated, my lord. Actually, 2 murder took place in the market. There is no eyewitness, nobody.
Double murder case, my lord.
And the person who actually gave the fatal thing, he is a juvenile. He individually acted upon it, my lord. So that way we have to segregate things, my lord. That's why.
No, we are just observing the confidence with Mr. Das is sitting here. So that's why we are thinking that it's not so complicated. Because
But
otherwise,
so far, I know, my lord, actually, this is a temporary arrangement because here, my lord, Julie Khan and this Bornali Chaudhary is.
because then we'll have to adjourn the entire matter. We can't keep hearing one part and then adjourn it because
As a
Constitution-
lordship, I have prepared it, but not fully.
Constitution, we don't know next
Yes.
week how we stand. This is, we'll take item number 1 to 4.
Yes.
One says, others are there in the item number 2 and 3.
Yes, ma'am.
You are there, okay.
Same to thing and
Both sides are to be represented. On a joint prayer made by both sides, the matter stands adjourned today. List in the next week.
Well, can it be on Monday? But we'll do it, well. Huh? Monday. Huh? Besides SCP, Monday we'll do it.
Oh, okay. 28th.
20.
Okay, list on 28/8/2023.
Much.
Sorry to mention one matter, my lord, because last posted on big 5-6 mile.
Mention, give it to the court master.
Mile.
Please, your lordship.
Yes.
Well, before I deal in the merits of the matter, I would like to give two facts for your lordship's kind consideration. Well, this is a judgment. This is an appeal.
You can read the FIR first.
Well, before I go into the affairs, I want to bring two facts. Your lordship, this is the second round of criminal proceedings. What happened, your lordship? There was an FIR was lodged on 2003. On the basis of that FIR, my lord,
You see, it doesn't help us to listen to the story first and then the facts. Because on the preliminary point, we are not deciding an appeal. So we'll have to go by the procedure because the knowing of the facts. Because we are not.
Definitely, your lordship is, I agree to that. But what my anxiety was there, that these honorable court has remanded back the matter once for at the stage of proceedings of Form 330. Because what happened in the earlier round, we were already been convicted. Then when the matter came before this court, a plea of juvenility was being raised and the non-recording of incriminating facts in the 330. Accordingly, this honorable court remanded back the matter to the trial court with the direction that first you decide the plea of juvenility with respect to one accused named Pranab Das. Second, if you decide the juvenility plea, then if he is not, then you proceed with the trial from the 313 stage. If he is, then he has to be proceeded under JJ Act. And with the rest of the accused, put the incriminating evidences which have surfaced in the evidence of PW 1, 2, 4, and 6. Now what happened, your lordship? After that, when this matter was been remanded back, your lordship will kindly see the impugned judgment. The 313 exercise, your lordship will kindly see the impugned judgment at page 67. Why I am trying to bring it one, your lordship?
Yes.
My lord is there. Your lordship will see the date of evidence. There are 8 dates of evidence, your lordship, when evidence has been recorded. Date of argument is 25/2015. Date of judgment is 12/6/2015. Your lordship is there. Now what happened, your lordship? The records reveal. When I was going through the records, I found that 313 was recorded on the date of the judgment. It was not recorded prior to the argument also. First. Second thing, your lordship, the order sheet reflects that earlier 313 is not found on record. That's why the learned trial court has recorded the 313 on the date of judgment.
Where is that?
Your lordship will see, my lord, LCR, order sheet. Your lordship will kindly see that I have got the certified copy, lordship, LCR, order dated
No, because what you are submitting does not appear from page 64. Look at page 64. 64 says, accordingly, my learned predecessor had conducted an inquiry, so and so, so and so. Then the accused Pavitra Das and Mantu Das were examined afresh under 313. Then opportunity has been afforded to them to adduce defense evidence, and then they have examined 2 witnesses. So this is what I have read.
No. Your lordship will kindly come to page number
64, read paragraph 7.
paragraph. My lord, accordingly, my learned predecessor has conducted an inquiry in respect of plea of juvenility. Your lordship, I have put the two earlier judgment in order, remanding back, your lordship. What I am trying to impress is that, and before going into the merits, I have got no issue, I will go into the merits. But there is a pertinent question that arises in this appeal is that, your lordship, when there was a direction passed by this honorable court on 5/12/2012, your lordship, I am reading the operative portion, which is at para 12.
Is this para 7 incorrect? According of the trial.
My lord, I am reading it. Accused Probita Das and Mintu Das are present. The record reveals that though both the accused are examined under section 313 CRPC on 25/4/2014 by my learned predecessor, yet the forms same are found not available on the record. So they are examined again under section 313 CRPC on today, and the forms are enclosed with the record. The accused have already adduced evidence in defense. We have already heard arguments of learned advocate on both sides. Now, if we pause here, your lordship, what reflects is that the learned trial court found that already both of us have adduced our evidences, and the predecessor has recorded 313, but that is not on record. Now, from the paper book itself will prove that it is a wrong recording of the order, because 313 was already there, which was recorded by earlier the predecessor with respect to the direction given by this honorable court. Now, number one. Second, your lordship, my question is that after you conclude your argument, and you fix the matter on judgment, can on the date of judgment, you can conduct 313 and subsequently 235(2).
I am not hard of hearing. I'm not, but don't be excited.
No.
I'm not hard of hearing.
My lord.
The fact is, you see, there is a counsel who is conducting the matter.
My lord.
The court records 313 statement. After recording of the 313 statement, the court finds, court allows you to give DW, and that is taken.
My lord.
Now what has happened, that the predecessor in office, when he finds that the 313 statement is not there, he reconstructs the 313. And that can't be done without the presence of the lawyer. So on the basis of the evidence which has been led by the defense witness, he just fills up the gap and does it. Now, is it a thing which will vitiate a proceeding?
My lord, if you see the proceeding which is during the particular chapter in the code, it talks about, as far as the 461 and 462, if I'm not wrong, my lord, it talks with magistrate. And as far as the other sessions, it comes under 463 with respect to place of jurisdiction, my lord, if it is a different session or not. My argument is, your lordship, I'm not banking upon on this issue only that this trial should be begin. I am just putting a query, your lordship, that when this honorable court has remanded back the matter to the trial court, with a two pertinent direction. Number one, that you decide the juvenility of accused Mintu Das, Pranav Das. If you find, you segregate, or otherwise you go by the session.
And that was done. The court found that the person was a juvenile,
My lord.
separated it.
My lord,
But what happens is that the 313 statement order sheet says it is recorded.
my lord.
Now that is missing somehow.
No, my
If
lord.
it is missing, the court is merely reconstructing the 313 statement, and that could not have been done without the presence of the lawyer. But the lawyer's presence itself shows that the proceedings, what do you call that missing document has been reconstructed in the presence of the lawyer. And then how does it? My question is that how does it vitiate? You'll have to demonstrate. How does it vitiate the proceedings?
My lord, for example, trial before the court of session is there, my lord, how the proceeding has to be done. Now, once you heard your arguments, and you fix the matter, just your lordship, once you heard your argument, you fix the matter on after 1 month for judgment. And on the date of judgment, you find that record of 313 earlier, which was being done, which was being recorded as per direction of the High Court, Honorable High Court, is not there. So you record the 313 on that very day, and you pass the judgment. Now, question arises is that on that day itself, can you prepare 313 and prepare the judgment, pronounce the judgment and sentence on the same very day? That means you have not taken the defense evidence or incriminating substances which has come which has been explained duly. That was never dealt in the judgment, impugned judgment. That I will show your lordship. Now, kindly come to page 58 of the paper
No,
book, your
you
lordship.
see, has the defense witness been taken in an abstract without the accused having knowledge of what 313 statement has been given?
No, my lord, in defense witness, I myself give my defense evidence,
It's okay.
my lord.
When a accused comes and deposes as witness in DW,
My lord.
after recording of the statement made in 313, are you saying that the evidence has been recorded in an abstract? The accused did not even know what defense evidence is to be led.
No, my lord. After
So therefore, you see, I ask you a simple question.
My lord.
In our legal system, we are recording the cross-examination.
My lord.
We don't record the questions.
My lord.
Correct?
My lord.
I can show you umpteen number of judgments where the courts, even at the level of when it comes to the High Court or when it comes to the Supreme Court, they reconstruct the question which has been asked. And this is the response. In a criminal trial also we do it, in a civil trial also we do it. We reconstruct the question that this was the question asked and this was the answer given. The question is not there on record. Therefore, you see, reconstruction of a question is something which is absolutely mechanical to a person trained in law. If you read a cross-examination, you can understand the question which has been asked.
Your lordship, my query is there. Your lordship, I appreciate this fact. Your lordship, in the paper book, how come the 313, which has been recorded by the learned predecessor, is there on the record? And how come this finding has been given that it was not on record? So the learned trial court has recorded.
Where is that? You mean you are saying that the earlier 313 is on record?
On record. Kindly come to page 58 of the paper book, my lord.
So you do not show us that.
My lord, kindly come to page 58.
You made so much of argument, you do not show us the first one.
Page 15.
58.
Now, where is the second 313?
Second 313, your lordship, will be lordship will kindly come
to page 45. My lord, it starts from page 39. And if your lordship peruse this 2-3-13 statement in conjoint, and if your lordship takes the Honorable High Court's direction was that with respect to evidences of PW 1, 2, 3, and 6 incriminating, which the learned session judge at that time did it. But the subsequent one, your lordship, all the questions have been put.
What is this date of the second recording of?
On the date of the judgment, my lord, 12/6/2015. At page 39, your lordship will find. The very same day when the judgment was pronounced.
Or my land just come out.
Oh.
Oh, en fin, on a une bonne façon, on savait. Ok, on peut faire ça. There's nothing. এটা এগুলো কি প্রবলেম? এটা জুভেনাইল ডিপ্লোমা অফিসার টু বিউটি পিপল। এটা সেম কেস নেই। ও আচ্ছা। Yeah, এটা তো this person is not before this court, juvenile. আপনি কি বললেন? Juvenile declaration was wrong, নাকি? Itu, how is this relevant in the present case? We other two court, this was earlier, Tamnekdon. Retrial is it not? When the three were remanded, that's it. We do know what they get out.
Miss Jahan, look at the record. It appears although it is not to our liking, but we'll have to remand it.
I'm told that all the 3% case was remanded from the state of region.
No, you did those, there are two flags that we have put. The first 313 and the second 313 are both on record. Our sessions judge does not know to see the records, did not find it. Recorded on the, re-recorded 313. Re-recorded 313 statement, which is already there, and then give the judgment.
He did not record 313 afresh.
Yes, afresh. Look at both. We have flagged for it for you. Both the 313 are there. No, we have put flags. We have put flags.
It's only one flag.
No, there has to be two.
Second 313. First 313. There's I think one flag, 313 statement 19.
Where did the second one go?
Second flag.
It is in the preceding pages, 5 or 6 preceding pages. There's a loose sheet. I think that loose sheet has gone inside, that's why. Next page. Yes.
This was an examination. Recorded on 25/4/2013.
Read the order of 12-6, order sheet of 12-6.
25 4. The earliest one. None of predecessor, yet the form C of form what they were. So we have examined it.
Just send it back that record.
Lots of this.
Just a minute.
What they are saying is, they did not find it in the record, 25 4. But the 25 4 there.
Just we want to look at something more. Yes, what you are saying?
Already, I have spent more than. I just got.
But this is 302. It will be life. Life means it will be remainder of the life.
Otherwise, it is life, because I would have taken initial and I would have been outside. Now, on the merits also, your lordship, there are fundamental flaws. Fundamental flaws. The lordship appreciate the entire thing and passes the judgment. Because if it goes by again, a formality will be done and again will be convicted. Again, I have to come file an appeal. The lordship, that trauma which is there.
But you can't, maybe in an appeal, would not like to proceed on the basis of the defective 313, because it is your plea now that the 313 being defective, it vitiates the judgment. So if that vitiation is there, then please suggest us how should we go ahead if we discard that 313 in the first place, the to take up the matter in appeal on the basis of that defective 313. Then we'll have to say that you get your the accused will have to swear an affidavit and tell us that he won't take the plea of being prejudiced. How should we go ahead if you are taking the plea that this?
The lordship, my plea was there.
Yes.
The lordship, what I wanted by making the submission. I wanted to tell there's another trial court below. With all humility, I must say, when one trial court is below, did not reduce the record in a mechanical way convicting.
No, it's you see, we have dealt with the trial court. I've been for about 25 years. I practiced there. It's not due to not knowing how to read it. It just it is just slipped. It's just missed.
And the lordship will see the include judgment. I will also come. I will just take some lordship. There were two issues. The first was the time of the incident. Time of the incident, your lordship, trial court is spent, it is 2 minutes. Now, but one aspect which the lordship, the trial court did was that.
No, first thing first. If you permit, if you have no objection that we proceed on the basis of the first 313 statement, then we go ahead on here and merit. If you say that it was the second 313 has to be relied upon, then we are at a fix. Because the evidence DW was taken on the basis of first 313 statement. So you'll have to tell us specifically, and we'll record it that you don't stand to prejudice if we proceed on the basis of the first 313 statement. Then we hear you on merit. So take a call if you want. We can give you time and take a decision tomorrow.
Because I have to read the client of the lordship and check in the.
No, that's why tomorrow day after, whatever you date you choose. Because the fact is that unless the appellant says that he won't stand prejudice, it will be a very difficult task for the appellate court to take up the matter and then decide on merit.
Because your lordship, I was going to the judgment, the evening judgment. The lordship. Not a single pack of the 313 aspect was been dealt in the evening judgment.
So that's okay, but once we enter into the merit, you will have to tell us that you don't stand prejudice. Because when the accused says that he is prejudiced, that is the paramount importance in a criminal trial and criminal appeal.
And I had informed the appellant because they are on bail, my lord. This court has granted them suspended their sentence of 2021 in a COVID period. So my lord, let me have a conversation and I will think the matter.
So we record what is transpired today. It should be on record. Record it again. Mr. M. Borgohain,
Yes, Lord.
S. Borgohain, counsel for the appellant, has brought to the notice of the court that upon remand of the matter by this court, the learned sessions judge found that one of the accused was a juvenile and the trial was segregated. And thereafter, the statement, the accused were examined under section 313 on 313 CRPC on first.
First one, your lordship.
25.
No. 25th April 2013.
25/4/2013. Full stop. However, as per full stop, it has been pointed out that as per order dated 12/6/2015 of the learned trial court, the learned session judge did not find the 313 statement on record, and therefore, on the date of pronouncing the judgment of conviction, statement under section 313, statement of the accused was examined under 313 afresh, and the judgment is impugned. The judgment impugned in this appeal is based on the subsequently recorded examination of accused under section 313. Next paragraph. The learned counsel for the appellant has shown from the LCR that the previous examination of the accused under section 313 CRPC is on record at page.
Page number, your lordship.
No. I have to write from here. At page 62A and 62B of the LCR. of file A of the LCR. The previous recording dated 25/4/2013. And that the subsequent examination of the accused under section 313 CRPC on 12/6/2015 is available at page 74 to 81 of the LCR. And I go to go from 62A to 62D. Next paragraph. Miss, after getting says Jan, the APP is present. I was here. Having heard the learned APP, on the court is of the considered opinion that it would be appropriate to give an opportunity to the appellants to take a decision as to whether they would like this court to proceed on the basis of the examination of accused recorded on 25/4/2013, or the subsequent recording made on 15/5/2015. Oh, sorry, 12/6/2016. Yes, 12/6/2016. 15. Yes. So that the appellant does not suffer any prejudice when the matter is heard on merit. The accordingly, the matter stands deferred today, and on the prayer made by Learned Counsel for the appellant, list on tomorrow.
As far as not there on the record saying that is a mistake. But they have to start afresh from 313 only as per the order.
No, we
After
are
that
not-
arguments.
Not that. The point taken by Mr. Mbawe is that if there's a fresh 313 statement,
Hmm.
which is exactly not in accordance with the first statement, then he should be given fresh opportunity.
No, what
Because-
this
No, no, no,
judgment says
no,
that,
no, no.
yes.
You're missing the point. You see, what has happened is this court remanded the matter back
Hmm.
to record a fresh 313.
Hmm.
Fresh 313 is recorded.
Put incriminating circumstance, everything, yes.
Whether it's there or not, we are not going into that mode. Whether it is there or not,
Hmm.
but it has been done and then DW was led.
Hmm.
Now, the DW is variance with the interpreting materials put before him. He stands prejudiced.
Of course, after DWs and everything are over, 313, then argument, then judgment.
It's something which is not envisaged in law. So therefore,
The steps are wrongly taken.
if we proceed on the basis that the first 313 is there,
Hmm.
then if the appellant wants that we proceed in that manner, taking into cognizance the first 313, then we take the bull by the horn whenever the judgment, if he assails, we will take it and decide on the matter of on merit on the basis of that. But if he says that no, you proceed because the court has only one option
Hmm.
to send it back and remand it. But he says that no, don't remand it, you hear it on merit.
Hmm.
So we hear on the basis of which 313 statement. That is the only question we are asking.
But it has to be, I think, subsequent because of this order.
I don't know. We leave it to the appellant. We are not
Because it's,
taxing our brain. We are not taxing our brain right now.
Hmm.
Let that exercise be done by the appellant.
Because then there will be one question will again come up, your lordship. One question, the question will be there, your lordship. Since if I go to by 25th April, the first 313. And if I raise the argument, if I raise the argument that the learned impugned judgment did not deal with 313, then it might come back.
So it has to be second because of disorder.
Second,
All incriminating circumstances were not put on the first, during the
No.
first.
in fact,
No,
there
no,
were
no, no.
330.
You are missing it out.
Three-
There are 313 statements.
Acha,
First, which was
three-
recorded earlier, matter remanded.
Huh.
Second, 313 was recorded. It was missing. Third, 313 was recorded and judgment was pronounced.
Acha,
So
this I
first-
didn't know.
First is shutout case.
Acha, that is gone. This is what I'm
First is
thinking
gone.
about second one. Acha,
Now we are on second and third,
acha, acha. Of
correct?
course. Then his, now I get it. I was not getting it. There were
Oh.
three.
There were three.
Then in that
Because-
case, of course, he has to decide.
Because if the matter is remanded, without 313, there can't be a judgment.
Uh-huh.
So one is there. We are just shutting it out because it's no use to us. You take this back, we'll give it on the next date.
After such a long delay or whatever, long period of incarceration, now again sending it back.
Well,
That,
that
of
is the
course.
issue.
Now
that
he
is
has
the
to
issue.
decide, of course, which 313 he wants to rely on.
And
No, because if we are in appeal, appeal can't be heard without a 313.
Ah, yeah.
Once we discard it, it is an anomalous situation. We can't do that. So
We
the
can
only-
see both and find out whether all
can't do that.
incriminating, of course,
you
that,
can't do that.
because argument was not
You
there.
can't do that.
2313, you can't take into consideration. It's for you to decide.
Yes, yes.
Why should we, what do you call, use our brain?
Number 6.
It would talk, Mula.
The lordship in this matter, can it be taken up on Monday matter? I don't know.
Not Monday. Monday, we have more than what we can handle through matters. And put it up on Wednesday if you want. Wednesday if you want.
It will be 30.
This is right. Both sides are duly represented on the fair made by land council for the appellant list from 308/2023. This is item 6. Yes, Ms. Sharma, your matter, item 7.
7 to 9.
Here, you have filed an appeal, she is not required to be heard. Correct. Huh?
I'm leaving to the lordship to carry it. I'm leaving to lordship, my lord.
No, no, because it can't be, once there's a jail appeal and a private appeal has to be take precedence.
Right.
So you just record her presence and you may leave, but we'll make you entitled to the, what do you call the, no, not that. We'll otherwise entitle you to the amicus curiae fees. So you may not be here if you are required elsewhere. You just in item 7, you write. Ms. B. Sharma, learned amicus curiae, as well as Ms. S. Jahan, learned APP for the state. Next paragraph. The learned amicus curiae has fairly pointed out that the appellant in this jail appeal has filed a separate appeal through his engaged counsel, which is registered as criminal appeal as 150 of 2017. To stop. In that view of the matter, as two parallel appeals is not envisaged under the law. The court is inclined to close this appeal as having been rendered infructuous in view of an appeal being criminal appeal 150 of 2017 filed by the appellant. Next para, however, having seen that the learned amicus curiae has put in a hard work since her appointment as amicus curiae for last 6 years, come on, she would be entitled to her usual remuneration. First. Okay, so we are assessing.
There is a order matter here in the supplementary list perhaps.
Yes, there is. Yes,
We were
What is-
supposed to get a report from the neurological doctor, I think.
I don't know, we've not seen it.
Because on the
Huh?
perhaps lordship was not there, lordship.
একটু রং না এটা ফ্রি করে দিও অর্ডার্স ম্যাটার
Actually, what is happening in this matter, if I just give a small background. This applicant, along with his two sons, were convicted. They were in jail, Morigaon jail. This applicant was having severe blood pressure issues because his blood pressure was ranging to above 200. So on a specific point, on a health ground, he was granted bail and said he would go for treatment. He went to GMCH. His another son who who's outside, he was brought to GMCH. Certain medical documents were examinations were done. The reports had filed in an affidavit. Subsequently, the order was passed that I need to go to GMCH again to do a neurological profile of my health. Now, what the issue is, the son who stays outside, they are treated as community people. They do not have much money to come and come to GMCH all the time. And then another son, Sushil Bordoloy, is a TB patient. He passed away this morning. I have his TB card, that the government card he gets. I have that, but I was informed that he passed away this morning. Now, the last order says I need to go to GMCH. I need to do my neurological profiling, and my bail is still today. I'm a 75-year-old person. The lordship takes up my affidavit, which I filed on 16/8/2023 in IA 646.
But I think there is some clarification. Lordship will see the last order of this court. There it is said that the documents that he has furnished on the last occasion, it had two advice slips from that same doctor to the same patient. So it was not believed.
So
And
was
in
earlier-
that,
was earlier one.
in that case, last occasion you were not there.
No, earlier one.
Uh-uh.
Main charge, answer my affidavit.
Thereafter, Lordship again, it will be clear from the last order. That is why neurological report was called for. He need not be taken to GMCH again, I think. On the basis of earlier reports, a neurological report was called. Huh? No, it wasn't last. अच्छा अच्छा
The lordship takes up page 29, an affidavit. It's continue, serial number page 29. Affidavit.
No,
filed on-
just one. इनमें सब mechanical काम कर रहे हैं। Yes.
In fact, yes, in paragraph 14, it's written, but the fact is the bunch of documents that he had given last occasion, although it shows that he had undergone some kind of a stroke, but then one stipulation was there that he is ready to discharge duties he has otherwise recovered. On that basis, that extension was not allowed as he prayed for. But it was written in one of the documents that as per advice of the neurological doctor, the report was made. So Lordship Michael Jothankumo was on the view that let the neurologist send the report. But then of course in paragraph 14, it's written that he should be again taken to GMCH where a report regarding condition of the applicant may be made by the neurologist. That he could not do. Otherwise, he is on interim bail for around 3 months by now. 2.5, almost 3 months.
Now he says that his son has expired.
Yes.
Now his son has
Yes,
expired.
madam.
Now,
And she can be just verified by the police. That today morning I have been informed. The under Morigaon police station, she can just give up.
no,
the copy of-
I'm not disputing his son
These are-
expired.
In fact, I may come up with another petition for the bail of his other two brothers for the rituals and all.
That I'm not disputing, but then he is on interim bail for long and then
What is-
otherwise Lordship can
No,
see
what we'll do is if his son has died today,
the.
we take, we take, what you call, we take note of your submission. And then give you 14 days with a direction that whatever your condition is, you'll have to surrender before the, whether you are good, whether you are ill, whatever condition you are in, you'll have to surrender. Without surrender, we will not consider your extension of prayer for extension of bail.
Once I surrender, the bail becomes effectual.
That's what we are saying.
If your lordship just for one moment, your lordship. can-
No,
what is happening.
you are saying that your son has expired. We
Yes.
take that into consideration, but after 2 weeks, you'll have to surrender. Otherwise, we'll not consider your application for
So,
extension of bail.
If I surrender, the bail, I have. to-
It will be a fresh application where you'll have to surrender. The order of the court has to be complied with.
Yes, madam, I agree to that. I agree to that. What I have given an affidavit today, that I have it on, the day before yesterday. I have specifically stated why I am not able to, why the son of.
No, we'll not consider that. That will not encourage. But then the trust of the court is lost.
I'll give it to you, lordship.
You had some difficulties, we are releasing you. But this can't be what you call a perennial affair.
I give it to you, lordship.
We are giving you extension for 14 days because of your death of your son. You are considering your age. But we make it clear that after that, this order will lapse and you'll have to surrender.
Okay.
If you want, you file a fresh bail application. Huh? Better. Yes, sir. Huh? But Mr. D.K. Bhattacharya, counsel for the applicants, as well as Mr. S. Jahandar and APP for the state. Next paragraph. This court by order dated 17/8/2023 had directed the report of the superintendent of GMCH to be placed before the court on 23/8/2023. First off, as per office note dated 19/8/2023. Oh, sorry, 23/8/2023, comma, no such report has been received. Next paragraph. The learned counsel for the applicants has submitted that as per instructions received today, comma, the son of the petitioner, applicant number 1
Applicant.
has expired today.
Son's name is Sushil Bordone.
Just right, comma, namely Sushil Bordoloi has expired today. Full stop. Referring to the next para, referring to the affidavit. Filed on when
22nd August.
you have a copy? 22/8/2023.
Paragraphs 3 and 5, I have explained my difficulty.
It has been submitted that the that due to poverty, the deponent could not bring his father to admit him in the GMC. Full stop. Next one. The learned APP has submitted that as per the documents which have been filed. Along with the additional document which is accompanying the affidavit filed on 17/8/2023. Comma, the applicant number 1 was fit to resume his duties. Next paragraph. You had been initially granted bail by this order date of 5/6/23. Next, the record reveals that by order dated 5/6/2023, passed in IA Criminal 469 of 2023, comma, the applicant is allowed to go on interim bail for 2 months with the direction that he would surrender after the expiry of 2 months. Thereafter, the applicant preferred the present interlocutory application, and this court by order dated 2/8/2023 extended the bail up to 16/8/2023 with a direction to surrender on 17/8/2023. And thereafter by order dated 17/8/2023, the interim bail was extended up to 24/8/2023. Therefore, considering the matter in its entirety, the court, on consideration of the age of the applicant, which is stated to be 75 years, and considering the statement made by the learned counsel for the appellant of the applicant at the bar that the one son of the applicant has died today, the court is inclined to extend the interim bail to the applicant, namely Brajeshwar Bordoloi, for a period of 14 days, ending on 14 days.
Today is 24th, so 24th.
Seven.
7th of
7/8/2023. To stop. The,
Can it be till 15 September? That's not humanitarian.
no. Once he's a convict, there's no humanitarian.
I had in fact relied on last day, Supreme Court has given bail to 70-year-old person.
His 389 was otherwise rejected. He is on only interim bail.
Only for medical reasons.
Only
No,
interim bail.
I've told the story many times in the bar. It will be a repetition if I repeat it.
I don't mind, but
My,
this matter,
no. My statement at the, to the bar, which I had addressed earlier, was that I went to the doctor at, for my health checkup. I was ill recently. So I went to the doctor for a health checkup. He checked me and said that you don't have a heart. At that point of time, I was taking up bail matters. So the doctors diagnosed that I had no heart. And he sent me back.
well,
So whenever I am taking up criminal matters, I am reminded of the doctor's advice that I don't have a heart. Can't help it.
Yes.
no, madam, but this person, his
No.
blood pressure stays at 200.
No, whatever
That
we.
jail
whatever
authorities will take care. And we will ensure.
They have the ambulance, they don't have the driver. That's the real ground.
That's okay. We can't help everything. We don't have answers for everything. That is why we are not government. The answers which are to be given by the government, not by the court. Next, accordingly, it is provided that shall have to surrender before the which jail?
Morigaon.
Morigaon District Jail. Irrespective of whatever health condition he is in, or whatever is the situation at his whatever situation which is prevailing in his home. First of all. As a condition for grant of bail, it is also provided that within 7 days from today, the applicant shall report before the jurisdictional police station uh, under which his house is situated. To have it, to have his presence recorded. For which the applicant is permitted to produce a downloaded copy of this order before the Morigaon Police Station. Next paragraph. On appearance of the applicant before the Morigaon Police Station, the officer in charge shall record his present and return back the certified copy. Having for the downloaded copy of this order, downloaded copy of the order of this court, for being produced before this court. Next paragraph. With the observations as observations and directions contained here before, this interrogatory application stands closed. Full stop. In the next para, it is provided that in the event the applicant appears before for his examination before the GMCH,
Within these days, he can go to the GMCH and get a report.
no, that's sir. What I'm saying is that and to bring it to the notice of the court if so advised.
All right.
Yes. Yes.
April also. Alert, there are two appeals pending. In the appeal number 150, the applicant is convicted for life. Person in German and order dated 27 passed by the Learned Session.
I'm sorry, I'm not hearing you. Is your speaker on?
Is it on?
Then we give you liberty to shout.
My lord. There are two appeals, my lord.
Yes,
In item number 8, my lord,
yes,
the appellant has been convicted for life, my lord, under section
Yes.
302 by judgment and order dated 27/2/2017 passed by the Learned Session case. Sipsago, my lord. And the other is in the second appeal, the other family members, my lord, they have been convicted under section 323 and 34 IPC. So your lordship kindly take up the first item, appeal, my lord. Appeal 150,
first, which is the family members. 150,
my lord. First, the second one, my lord, 158, my lord.
158. You want us to take that? 158.
My lord. One 58.
Yes,
Judgment you also will find page 9 onwards, my lord. It has been passed in sessions case number 286, my lord, 2013. convicting the appellant for life.
You're going by the paper book because this is
Yes,
same
my lord.
paper.
I have the paper books. my lord.
You may read from there, whatever way, from the memo appeal you want, because I'll be referring to this page 45 onwards because it's easier.
Yes, my lord. Kindly take up the first my lord, FIR, my lord. In the paper book, page number 4, my lord. Page number 4 of the paper. Page 4. my lord.
Yes.
Married. The humble submission is that about 6:30 AM today, our neighbor Sri Raju Satnami, his wife Srimati Gauri Satnami, Sri Saju Satnami, his wife Srimati Beena Satnami, and mother Srimati Sunti Satnami, in a body, quarrel with my mother Srimati Onima Mehra near the water tap in front of our house at factory line. My elder sister Onita was also assaulted when she was went to separate my mother from them. In the meantime, Saju Satnami dealt blow on the head of my mother, as a result of which my mother sustained injury. My mother was immediately admitted to the hospital of Borbamti Estate. Later, about 7:30, this is important, AM, Raju Satnami hacked my mother with a dao in front of nurse and doctor while my mother was undergoing treatment, thus killing her on the spot. Therefore, prayer was made to take necessary steps after investigating into the matter. The name of the informant was, the lordship kindly note, my lord, Solomon Satnami. Page 5. Yours faithfully, Solomon Satnami, the informant, son of Samu Mehra. So and so on. Thereafter, after police investigated the matter and submitted the charge sheet, your lordship will find page 6 onwards, my lord. Please. Charges, my lord, framed by the learned court below. And after framing of charges, my lord, the copies were, it was explained to the appellant, the accused persons, and my lord, trial was commenced. To bring home the charges, my lord, the prosecution has examined, my lord, as many as they have examined as many as 8 witnesses, my lord. Excluding my lord, the MO and the investigation department, totaling my lord, 10 witnesses in the present case, my lord. Thereafter, my lord, the prosecution examined my lord PW1, see, Hori Mohan Mehra, my lord, page 10. May I read the my lord, evidence, my lord?
Yes, yes, please.
Page 10. His name is Hori Mohan Mehra, my lord, son of Samu Mehra. The examination chief, my lord. I know the accused persons. They live near our house. Incident happened on 5/9/2013 at about 6:30 AM. They had a fight with my mother over water. I was that.
This, just a moment. Yes, Raju Satnami and Saju Satnami are same person.
Brothers.
Brothers, my lord.
Saju is different and Raju
Raju is
different.
different. Their brother. The incident happened on 5/9/2013 at about 6:30 AM.
And ladies are the wife. Gauri Deveshwari is the wife of Raju. And Beena is the wife of Saju. And Sunti is the mother.
Mother.
Entire family.
They had a fight with my mother over water. I was studying at home. When she came home, she bleeding on me. Asking, she told me that Saju Satnami had hit her with a bucket in the head, and that the other have also hit her. Then I took her to the garden hospital. My mother was in the Basti house. So my father was in the Basti house, and my elder sister had gone to call him. I got her admitted in the hospital and came back. My father also arrived and I told him what happened. Then we went to the hospital. She was in bandages. Then both of us went to the VDP who told us to file an FIR. Then we came to the police station and filed the FIR. It was written by Sri Prabhat New and he read it over to me. Then we received a phone from Syam Paik, Sokidar, and he told us that Sri Raju Satnami had cut my mother with a dao in the hospital itself. I then wrote it in the FIR. My father went with a 108 ambulance. I went later. They did not allow me to see her and at the first, but later on I saw the body of her neck had been severed. The police also prepared the inquest report and also questioned me. Exhibit is the FIR. Kindly note this, my lord. FIR was in fact lost by Soru Mohan, my lord. Now it is Harimohan Mehra claimed that he has lost the FIR. Exhibit 1 is the FIR. Exhibit 1 is my signature. Exhibit 2 is the inquest report. And Exhibit 221 is my signature. Kindly note it, my lord. FIR was lost by Sorumohan Satnami, and the now my lord PW1 claimed that Harimohan, he lost the FIR before the police.
So Roman is examined or not?
Sorumohan was not examined.
Not examined. Soruman is perhaps the same person.
There was also not mentioned anyway.
He is writing Mehra.
Cross party lordship, page 11.
Please come again.
My lord, PW1,
Huh.
his name is Harimohan Mehra.
Huh.
He stated before the court, his name is Harimohan Mehra, and he claimed that he lost the FIR. But the FIR lordship goes to page 5, my lord. The persons who lost the FIR, his name is Soruman Satnami.
Oh, no. Come to page 10 of the paper book.
My lord. I'm reading from 10, my lord.
Look at the signature. The court has written Hari Mohan is okay,
My lord.
but the person is signing as Saru Mohan.
My lord.
It doesn't make a difference.
Satnami.
I make a mistake daily.
Yeah.
When I address the learned
I know.
counsel, maybe perhaps instead of
It's a trial,
then
my
I
lord.
no, it's okay.
It's a trial, my
But
lord.
no.
It should be proved beyond all reasonable doubt, my lord. That is the criminal,
No. You see,
edifice of criminal justice, my lord.
I am recording. I am hearing you
My lord.
instead of PJ. What do you call? Sakya, I'm writing your name as PJ Fukar.
My lord.
Correct. Does it make a difference? Can somebody say that, well, the lawyer having the Vakalatma was not heard? It's a mistake of the court writing the name. Writing of the name is not fatal.
Court does not write the name, my lord, on his own, my lord. On declaration by the person concerned who deposed before the court.
You see, what did I ask the first question? Raju and Saru are the same person.
My lord.
Because
Nowhere it is stated, my lord.
no. If you are saying Raju, I may hear it Saju.
That is different. But it's a court of
You know,
my
when
lord,
the-
criminal
when
trial,
there
my
was
lord.
there was about 20 years back, there was a program called Dragon. What do you call? It was called Dragon.
Yes.
You could dictate to that dragon and it will write. So when I initially purchased it, I could not pass out 3 lessons. Because they were taking up English, which is not Indian English. They will take an English which is UK English and therefore US English. And therefore I couldn't pronounce that English as the people in the US do. And the dragon rejected my speech. My entire money which I spent at that point of time, 20 years back, went down
Right,
the
that is
drain.
everything all right, my lord.
No,
But
it's
it's a
okay.
criminal trial, my lord. The person has informed the
no.
court that his name is Hari Mohan. But while he signed my lord, he signed it, my lord, Solomon Mehram. Complete
It's
different
okay.
person.
In fact,
It's
that
okay.
software even we thought of purchasing, but then we came to know that it doesn't understand. So we also
Everything is
That
made up.
was smart.
have.
I was not smart.
No, no, we cannot be. We have this accent. So
That's not substantive. It's got that argument will not we will disinclined to accept. It is the court which is which is dictating,
My lord.
and the typist is typing it out. Correct.
Prosecution
If
has
you, I'll welcome you to come into my chamber and look at the amount of paper we waste when the dictations are transcribed. I'm writing something which is transcribed like something, and then when we correct it, then you find that this spelling has been wrongly taken. It doesn't affect the merit. His name is okay, his father's name is okay, his house is okay, police station is okay, so the identity is not disputed.
no man. His surname is Sotnami. Now he writes as Mehram.
You look at the name of our prime minister. Maybe 90% of the people won't know his second name.
Yes,
Correct.
my lord.
So we call him by the first name and the
Son.
surname. So will it make it that the citizen of our country doesn't know his name?
My
No.
lord. My
We are
argument is,
identifying
my
it
lord,
by whatever name you want.
my argument is same, my lord. Since it's a criminal trial, my lord, there should not be any shadow of doubt.
No. It's not a doubt.
He write in the FIR, my lord, he written his name. He's written as Solomon Satnami. Now he signed before the court below, my lord, Solomon Mehram. And the court has recorded his name as Hari Mohan Mehram.
You see, did you ask him that question in the cross-examination?
My lord, that was
In
not
appeal,
there.
you want
That
to
was
argue
not
that.
there.
No, you won't take that.
In the cross,
Second, there's something which we can't take. You dispute the identity there and there
my lord.
when you are being cross-examined. Not now. If I record the number, just I told you, I'm hearing Mr. Saike, I write Mr. Pukal. That's not a substantive error, which because I make that mistake daily.
My lord. If your lordship goes to the IO statement, I also recorded that he is Solomon, my lord, not Hari Mohan or something other.
You see, that
In
was
the-
never disputed.
In the cross examination, your lordship
That
can.
was never disputed.
That was not put in before.
It's not a dispute of identity, it's a dispute of spelling. Incorrect, what you call, recording of the of a name does not vitiate the proceedings. It does not vitiate the proceedings. Maybe because spelling has been wrongly entered.
Not only spelling, but title have been changed, my lord. Title is changed. Somewhere it is Mehra, somewhere it's Satnami,
It's okay. I'll put you a simple question.
my lord.
Correct. There's a person called Ram. In Mahabharata, you find the same name Ram, but it is written as Rama Rama.
Yes.
Correct. So so if somebody writes the name as, if I take the deposition and I'm writing the name of Ram as Rama, will it change the identity of the person just because I have added A there? People pray, pay obeisance to that Lord Ram, but they write it R-A-M-A. Rama was never the name. Has anybody protested anywhere till now that there is a substantive, what you call, assault on the religious belief of the countrymen, and therefore historically it should be made correct? No.
No.
But I tell you, there was a great lawyer who told me the answer. Mr. Chandicharan Deka. He was a civil giant. I put him this question about Lord Ram, and his answer was very beautiful. That's why I never forget, and this is the easiest example I can give. His reply to me was that in Assam, we have the answer to that. And his answer was very simple. That when we do Hari Kirtan, then the same thing, Hari, H-O-R-I. In Assam, it will be H-A-R-I. We are writing. Hom is written as A-S-S-A-M. Will it change the name of the state? Simply because in Assam, we pronounce it as Ahom. It doesn't change. Nothing changes. In a few newspapers write AXOM. Yes. Correct. So is the identity changed? Is it a new state which has been created? No. But the answer Mrs. Chandicharan Deka gave was, when we make a prayer, then we say Ramo. Correct. When you do that Nam Kirtan, then Ram is not called Ram, it is called Rama. He said that, well, we say Rama when we pray to the God, but then we also say Ram Sam Jadu Madhu. Correct. So it is clear to you now, name does not make a difference, merely because I write it wrongly. So I have an answer to that.
Depends on the context.
Huh?
Depends on the context.
So right,
Yes.
you see, we call it Hari. Does anybody write H-O-R-I?
We write H-A-R-I only.
Then merely because, so supposing I hear you writing you telling your name as Hari, I write H-O-R-I. Will it create a different identity of a person?
That's what.
No. For example, your first name. I can write it in 3 different ways.
Yes. Shamima can be written in so many ways.
Yes. We call you by a nickname.
Your trip is.
Now J-U-L-Y.
Yes, Julie. Yes, of course.
Yes. And J-U-L-Y is also July. Then will it change the identity?
Yes, yes.
It doesn't. So therefore,
Too fragile a statement.
you see, I'll tell you very simply. Number one, the PW1 saw you assaulting. PW1 saw this Raju assaulting.
No, he did not see.
He did not see.
Mother came and told him.
He did not.
Mother told him. Eyewitness is PW2, Anita Mehra.
Sister
She-
is
she-
there.
There is no eyewitness, my lord.
Yes. She's
No,
an
my lord.
eyewitness.
She is not eyewitness.
The first instance, she is the eyewitness. Second instance,
Huh.
the doctor and the one ward boy, yes. Even they did not see it that clearly, but then they saw him going out with the bloodstained
Only
machete.
doctor and my lord, ward boy, my lord.
Sister
They
is
claim
the
to be seen
witness
there.
to the first.
Commission of the office.
Then PW4 and
PW4. Yes,
PW8.
Yes.
Yes.
They saw the person coming out from the that room,
Yes.
the infirmary room, infirm room, and with a dao. And PW, the doctor,
Kalyan.
he said that it was blood-stained dao.
Bloodstained.
And
But
then-
the other witness only, PW8. He say, my lord, he did not see any blood on the my lord.
So definitely, he saw him going out. The blood is something you will not notice in a dao.
That is my lord,
Somebody may have
suspicious.
missed it.
That is suspicious.
He was a dresser only.
No, I'll
Hello.
tell you, this, you see, this discrimination doesn't carry a meaning. I'll tell you why. It's a very simple example. If I ask you that today, when you entered this courtroom, a particular man who was standing in the the police person who is standing in the gate. You crossed him and came. I asked you the description, how was that man? You will not notice it. Because that was never an idea when we were entering the courtroom to watch this person who is the police personnel guarding the gate and to give his identity. Now there are children, when they see a car passing by, they will tell the car model name, the year of make, the features of that car. I have seen boys who see a foreign car just passing by and they'll give the entire description of the car, along with the torque, along with the what you call the maximum speed it can give, the manufacturer's name, year of the model, and people are so acquainted with that. If you have missed out that, go and watch the movie which is called My Cousin Vinny.
Yes, I've seen it.
It's a movie which a lawyer should
Always watch.
see, My Cousin Vinny. When it comes to description of car, I may not notice that which car has gone by. To my eyes, maybe it's a Dow, maybe it's a Hyundai. I don't remember. But there are some people who remember. There are very simple example, which you all will recollect. It happens in my home. I don't know whether it happens in your home or not.
My
My
lord,
wife can recollect that when she went to a place on Sunday, she had worn a particular dress. Day before, about a year back, she went to the home of the same person about a year back. At that time, she was wearing the particular dress, and so therefore she will not repeat that dress again. Correct. It happens to in my house. I don't know about your.
circumstances in this case
No,
are
no, but you see the
completely different.
memory. You see the memory. The thing which you want to remember, you remember it. If you see an accident, if I ask you the question, have you seen the passenger of the vehicle, what color of shirt he was wearing? You will not notice the shirt. But there are some people who will remember by color. I like yellow color. And therefore, if I find a passenger in the car who was wearing a yellow dress, I'll remember it, that yes, he was yellow. Inadvertently, I record that in my memory. So therefore, you see, there can be a misdescription of a person merely because somebody has not noticed it. Somebody will say, well, I saw it maybe 5 feet. Somebody will say, no, not 5 feet. It was 5 feet, 6 inches. So you see, those things are a description which is not fatal unless the identity itself could not be proved. And there are untold numbers of judgments. I can show you not one. I can show you untold numbers of judgments where misdescription does not lead to a dispute in identity.
Well, here, 3 persons are there, according to the PW4. The ward boy himself, the doctor, and the my lord victim. Doctor has seen the blood, the Dow with blood. The ward boy has not seen the Dow with blood. This is peculiar circumstance, my lord. It cannot be brushed aside.
No, surely not.
And except those 2 witnesses, my lord, nobody has seen everything.
You see,
And
what is important is that somebody is coming out with a Dow. In a hospital, you don't go with a Dow, number one. And number two, after you come out from a hospital with a Dow, You don't have a patient who is dead with the neck severed. Well, it is unusual for somebody to go into a hospital with a dog.
But the hospital my lord, belongs to the my lord, tea garden.
You see, it's not a traditional attire. my lord. For example,
It's not
a
traditional.
person belonging to Nishi tribe
Yes.
in Arunachal. He is normally armed with a sword.
Yes.
The communities in Nagaland, where it's a tradition, they will wear that and walk. In a Sikh, there's a tradition to wear a kirpan and then travel. This person is not habituated to have this carrying a dao in the hand.
So they are on duty, my lord.
No.
In tea garden, my lord.
No,
People
no.
are always moving with a dao, my lord. After 7 a.m. to
No.
5 p.m. or 6 p.m. my lord.
It will not be a dao. Dao is a weapon of assault. I can understand Hasia. I can understand any other equipment which is associated with the tea garden. Dao is not a weapon which is associated with plucking of tea. Dao you'll never find. Because this tea garden laborer, they've got nothing to do with a weapon. Dao, this Hasia and all, they are not required to keep it. Because it's only plucking.
No, my lord. It's not that. They are the parts of their work, my lord.
It will not be.
They
The
used to
gardens-
cut trees, my lord. They used to cut trees, my lord, to clear fallen trees were everything, my lord. With dao and kolom kotari, my lord, they call it, my lord.
Kolom Kota is not a dao.
My lord. But the facts remain that the police has not recovered that dao or kolom kotari, my lord. What they call it. The total discrepancy between the two, alleged items, PW4 and 8.
Yes.
Mayor, PW4 page 15, my lord, evidence of the doctor, my lord. I am presently serving as senior medical and health officer, Borbam Tea Garden Hospital. I know the accused. Incident happened on 5/9/2013. I was on duty in the hospital. PW4 I am reading. Page 15.
Yes.
I am presently serving as senior medical and health officer, Borbam Tea Garden Hospital. I know the accused. Incident happened on 5/9/2013. I was on duty in the hospital. There was a fight between the parties and both parties had simple cut injury and I treated them. Anima had simple cut injuries in her head and was kept for observation in the room in front of my room. It was about 7 a.m. After about 20 minutes, I heard a shout and I came out of my room and saw the accused Raju Satnami coming out of room with a blood-stained dao. That is dao. I went to the room and saw Anima lying in the floor and bleeding. She had 2 cut injuries in her neck. The manager then informed the police. I was also questioned and did inquest and took the body for postmortem. I signed the inquest. Exhibit 2 is the inquest report. Exhibit 2 is my signature. Cross. My duty time is from 7 a.m. to till 10 a.m. The ward boy Sukra Udan was there. The deceased was not in a room but in the observation room. There were some other patients. Other patients also there, like Devestori Satnam and Sadhu Satnam in the male and female wards. I know Raju from 2006 as he is a worker in the garden. I have not seen the accused cutting. Police did not take me for test identification period. It is not a fact that I got to know the name of Raju from some other person. It is not a fact that I have deposed falsely and only on suspicion. It is not a fact that I did not see Raju Satnami. I saw him from front side only. Now you'll also kindly peruse page 20 mile. Evidence of Supra Urang mile word board. I know the accused Raju Satnami, Saju Satnami, Bina Satnami, Sunki Satnami, and Devasari Satnami. They are not present in the court today. Incident happened in the year 2013. I was on duty as a dresser in the Borbam Tea Garden Hospital. My duty started at 6:30 a.m. The doctor was Dr. Kwellan Borba. I was attending to the patients and I went to the pharmacy and saw Raju Satnami going outside with a dog. I did not notice if there was any blood in the dog. Immediately, doctor has seen there is blood in the dog, and thereafter the ward boy has seen there is no blood in it. Then doctor sir and I went. So Nima was lying on the floor and was bleeding. Then doctor had shaked her and found her dead. She has injuries in her neck. Police questioned me. There was a fight between Raju and Anima family in the morning due to page 21. I do not remember the time of the incident. I have not seen the fight between the families. The family members of both the families were the patients in the hospital on that day. It is not a fact that I have deposed falsely and that the incident happened during night. I could not recognize who cut. I have not seen him cut. These are the two witnesses, my lord. Witness number 4 and the witness number.
But you see, have you noticed in the cross-examination what has happened? There is an admission of fact. You read that last line again.
There was a fight between Raju and Anima family.
Then,
It was admitted, my
no,
lord.
no, then
In the morning due to water.
no, no.
Page
The
number
incident happened during the night.
10. Yes, my lord.
So therefore, you see, when the accused is asking that the incident did not happen in the day, it happened in the night. So it is an admission of the fact that the incident happened. Incident happened, it is only a dispute of time. You see, it's your cross-examination. Your cross-examination is what? Incident did not happen in the day, it happened in the night.
Yes.
Therefore, the incident happened is an admitted fact. So now it's only a dispute of time. The doctor says that his duty is from 7 a.m. to 10 a.m. The witness PW8 says 6:30. He came to the duty.
Yes.
So therefore, the duties, it is apparent that is in the daytime. We'll take a short break and come back. Reassemble after 5 minutes.
Since others are not relevant in this case as they have not seen the occurrence. Page 23.
Yes.
Ayo Nandeswar Dr. I'm serving as the law instructor at Police Training College, Jaigaon. On 5/9/2013, I was serving as officer in charge Amguri Police Station. On that day, at about 7:30 a.m., the complainant Sri D.K. Hazarika, welfare officer of Borbam Tea Estate, informed me about the incident over phone and I made a GD entry number so and so, dated so and so. Then I rushed to the place of offense to start investigation. There I found dead body of Onima Mehra on the floor of one of the rooms of the hospital. The executive magistrate was called and Sri Utpal Dole came. An inquest was done upon the body and body was sent for postmortem. I drew the sketch map of the place of offense, took statements of witnesses. On that same date, the FIR was lodged by Sorumon Mehra. Now it is also Sorumon. And same was registered by me as Angui PS case number so and so, so and so, so and so. I took the investigation upon myself. The injured was sent for medical. I also arrested the accused person, Raju Satnami, on 6/9/2013 and produced him before the court. And the rest were arrested on 20/10/2013 and produced before the court. I collected the injury report and postmortem report. Thereafter, on 23/10/2013, I filed a search sheet against all the accused persons under section 147, 148, 149, 325, 302 of IPC. I did not
Now,
make it.
now you understand why the name is not so very important. Because the line you just read, 325/302 of the
IPC.
is Indiana, but you have read is Indian. Correct? But in type it is written Indiana, Indiana Jones. So
I think
therefore,
This is also
this is what
important.
I was trying to impress upon you.
Yeah.
Because there are certain things we become acquainted with, and therefore the mistake which has happened in the typing of name or writing of name doesn't matter to our brain. I'm just making a passing remark.
It's a criminal trial, my lord.
No, it's
Personal
okay.
liber-
No,
involvement
I'm
of
just,
personal liberty is
no,
not-
it's okay. I'm not questioning you. I'm just demonstrating from what you have read. That in fact, if in the
That-
brain we are always accustomed to Indian penal code, even if it is written here as Indiana penal Jones penal code, it did not strike to our mind because our mind is such a sharp, what you call, thing we have that it can mask which it doesn't want to read. I'm
Next.
just giving an example.
Next line.
Yes,
I did not make any seizure.
yes.
As the accused Raju Satnami has stated before me that he had thrown the dough in the river. I had taken 2 photographs of the dead body lying on the floor. Exhibit 1 is the FIR. Exhibit 2 is the 1 is my signature. 4 is sketch. 4/1 is my signature. Exhibit 5 is the search sheet. So and so.
Yes.
Cross part, you'll also find page 24. I have done the complete investigation of the case. I took the statement of 12 persons at the place of occurrence itself. I have taken the statements of other witnesses who are not related to the disease at the place of occurrence itself. It is not a fact that I had taken the statement of witnesses in the police station itself, that I have not gone to the place of occurrence and filed this false search sheet against the accused person. So from the evidence of PW10 by IO, it is clear that he does not make any endeavor to even to recover the weapon of offense, nor it has been stated in which river or in which place it has been thrown to. That is important. Then the accused statement under 313 were recorded by the learned court below. Page 25 onwards. And he denied everything, my lord. Questions put to him, my lord. Ultimately, the Indian judgment was passed. Now, your lordship kindly hear the judgment, the Indian judgment. I'm reading the para 6, my lord. The following points are being considered for adjudication and of the instant case. Page 12 of my appeal, my lord. 150. And the reasons, overview of the evidence on record and the conclusion thereof on page 13 of my appeal, 158. 70. And it is page 48 in the paper book.
Yes.
Para 8. PW1 is the informant, namely Hari Mohan Mehra. And he testified that the deceased Onima Mehra was his mother. On 5/9/2013, at about 6:30, he was studying at home and saw bleeding injuries on her head when she returned home. She informed him that the accused person had quarreled with her over supply of tap water, and thereafter accused Saju Satnami hit her with a bucket on her head. The other accused person had also assaulted her. He took his mother to the hospital situated at the tea garden, and thereafter he came back to his home. At that time, his father and sister were not at home. Thereafter, when his father came back, he told him about the incident. After consulting the members of BDP, whom they were contemplating to lodge a case at the police station. At that moment, the tea garden shopkeeper, namely Syam Paik, he was never, my lord, made a witness in the case, my lord, informed him over telephone that the accused Raj Satnami had assaulted his mother with a machete and in the hospital itself. So they lost the Ezahar accordingly, which was written by one Prabhat Neil. They rushed to the hospital again and found the neck of Onima Mehra severed. He lost the Ezahar, that is exhibit number 1 at the PS. He was a witness to the inquest and exhibit to his inquest report prepared by the police. In cross-examination, PW1 has testified he did not witness accused Raju Satnami killing his mother at the hospital. The PW1 further categorically testified that he suspects that Raju Satnami had killed his mother due to quarrel in the morning at a water tap of the locality. PW2 Vanita Mehra has testified this was her mother. On 5/9/2013 in the morning, she heard sound of commotion, and when she rushed out, she saw accused Gauri Satnami, Bina Satnami, Sumki Satnami hitting her mother near the water tap of the locality. When she went there to rescue her mother from the clutches of the accused persons, they assaulted on her hand as well. So she went to their village house where her father was staying at that time. Her brother, that is PW1, took her mother to the hospital. Thereafter, she, along with her father, went to the hospital. Her mother informed that the accused Saju Satnami had assaulted her with a bucket on her head. She left the hospital about 7 a.m. and subsequently heard that someone had assaulted her mother. So he rushed to the hospital again and found her mother lying in the floor amidst pool of blood. She became unconscious on seeing the scene of crime, and when she regained consciousness, Dr. Koilan Bora informed her that the accused Raju Satnami had killed her mother by assaulting her with a machete. In cross-examination, PW2 has testified that she did not witness the incident at the hospital. The accused person had fought with her mother on the previous day of the incident as well. PW3, Samu Mehra, husband of the victim, he testified that on 4/9, he has since date is changed, man. Accused Bina Satnami had fought with his wife, Anima Mehra, relating to supply of tap water in their locality. He went to his village home, and on the following day, that is following day, the PW2 came there in the morning and told him that the accused person had quarreled with his wife. He rushed to his home and came to know that his wife had already been shifted to hospital situated in the tea garden. So he went there and saw injury marks on her head. His wife informed him that accused Sazu Satnami had hit her over with a bucket. He consulted the matter with the secretary of VDP, namely Dhiren Tati, who advised him to lodge an FIR at the police station. When they were at the police station, his son, that is PW1, received a telephone call, whereby he was informed that someone had assaulted his mother. When he reached the hospital, he saw a crowd gathered there. Dr. Koilan Bora told him that the accused Raju Satnami had killed his wife with a machete. He saw 2 cut injuries in the neck of his wife. In cross, has testified that he did not witness the incident. Paragraph 14. PW4 Dr. Koilan Bora and he has testified that he was serving as senior medical and health officer at Borbamti and 5/9/30, and he was on duty on that day. There was quarrel between the party, and they had sustained simple injuries on their person, and he treated them. Anima Mehra had sustained simple cut injury on her head and was kept for observation in the hospital in a room, which was situated in front of it. It was 7 a.m. and 20 minutes thereafter he heard hue and cry, and when he came out from his room, he saw the accused Raju Satnami coming out of the room of Anima Mehra armed with a blood-stained machete. So he rushed to the said room and saw Anima Mehra was lying on the floor and blood was out from her neck. But the doctor, while giving evidence, he stated that he, along with the ward boy, went to the room. That was not discussed by the land court. She was dead by that time. He had signed on the inquest report, exhibit number 2, as witness. In cross-examination, PW4 has testified that he was on duty on the relevant day from 7 a.m. to 10 a.m. Ward boy Shukra Urang was there in the room, where Anima Mehra was kept for observation. This is important. Shukra Urang was there in the room, where Anima Mehra was kept for observation. Accused Deveswari Satnami, Sazu Satnami were also at the hospital at a relevant time in the male and female wards. He knew Raju Satnami since 2006 as he was a worker in the tea garden. He did not witness the actual assault on Anima by accused Raju Satnami. PW5, he testified that on the day of incident at about 6 a.m., the accused person had quarreled with Samu Mehra over supply of water in their locality. Thereafter, 1 hour later, he heard the sound of commotion and came to know that someone had assaulted Anima Mehra at the hospital. Subsequently, came to know that accused Raju Satnami had assaulted Anima. So he rushed to the hospital and saw the dead body of Anima Mehra there in a pool of blood. He was a witness to the inquest. Exhibit 2 is the inquest report conducted by the police. Paragraph 17. In cross-examination, PW5 has testified that he did not witness the incident that occurred in the hospital. Paragraph 18. PW6, the medical officer, namely Rupam Borkakoti, he has testified that on 5/9/2013, he had conducted autopsy on the dead body of Anima Mehra and subsequently submitted the post-mortem report, which is Exhibit 3. PwC 6 has opined that he found cut injuries on the neck of the deceased and she had died due to severe hemorrhage. The injuries were anti-mortem in nature and she had died due to hemorrhagic shock. Para 90. PW6 has been declined by the defense. Para 20. PW7 is the Deepak Kumar Hazarika, and he testified that on 5/9/2013 he was present at the factory office of Borbam Tea Estate. At about 7:30 a.m., Dr. Koilan Bora called him over telephone from the hospital and informed him that a fight took place between two families. Out of that fight, Onima Mehra sustained injuries and she was receiving treatment at the hospital. Dr. Koilanburu had also informed him that one Raju Satnami came to the hospital and assaulted Onima Mehra with a message. So he consulted the matter with the manager of the tea, namely Talat Ahmed, and rushed to the hospital and informed the matter to the police. He found a dead body of Onima Mehra lying in a room at the hospital and saw injury marks on her person. In cross-examination, PW7 has testified that he was the welfare officer of the tea estate at a relevant time. He did not witness the incident. Paragraph 20. PW8 is Sukra Urang, and he has testified on the relevant that day he was on duty as dresser at the hospital of Borbam Tea. He was on duty from 6:30 a.m. on the relevant day. Dr. Koilan Borua was on duty doctor on that day of incident. At the relevant time, he was attending to the patients, and when he went to the pharmacy, he saw Raju Satnami coming out with a message. Earlier, they have said "Thou man." So he, along with the aforesaid doctor, went to the room and found Onima Mehra lying on the floor amidst pool of blood. The doctor checked her and found her dead. She sustained injuries on her neck. He heard that there was a fight that morning between Raju and Onima due to supply of water in the cooker. In the cross-examination, PW8 has testified that he had not seen the fight that took place between the aforesaid families. The family members of both the families were admitted in the hospital on the relevant day. He did not witness the incident. Paragraph 24. PW9 is Utpal Dole, and he has testified that on 5/9/2000 he was serving as circle officer at Amguri Revenue Circle. On that day, he conducted the inquest over the dead body of Onima Mehra in connection with so-and-so case. The inquest was conducted at the hospital at Borbam Tea. He saw deep cut injuries on the neck of the dead body, which was caused by surgery. He further testified that Onima Mehra
Yes, please continue.
He had further testified that Onima Mehra died due to excessive bleeding. Exhibit 2 is the inquest report. Paragraph 25. In cross-examination, PW9 has testified that he saw plethora of blood stain in the neck of the deceased. Paragraph 26. PW10 is the investigator, namely Nandeshwar Datta, and he testified that on 5/9/2013 he was serving as OC of Amguri Police Station. He had conducted the investigation of the case. He found the dead body of Onima Mehra lying on the floor in one of the rooms of the hospital. The executive magistrate, namely so-and-so, had conducted the post-mortem on the dead body of Onima Mehra. This executive magistrate so-and-so had conducted the post-mortem on the dead body of Onima. He had drawn the sketch of the PO, and exhibit 4 is the sketch map. After winding up of investigation, he had submitted the search sheet against the accused person under section 147, 148, 149, 325, 302 of the IPC, and exhibit 5 is the said search sheet. He took photographs of the deceased when she was lying on the floor of the hospital. In cross-examination of PW10 has testified that he recorded the statement of 12 witnesses under section 161 of CRPC at the place of PO itself. para 20. From the evidence of star witnesses, that is Dr. Kailan Borua. It has been percolated that he was the only eyewitness to the incident. Page 53, paper book, para 25. Para 28. How the evidence has been discussed by the court below. From the evidence of star witness, that is PW4, Dr. Kailan Borua, it has percolated that he was the only eyewitness to the incident, which is totally wrong, Mile. Who arrived at the PO, that is the hospital room, after hearing hue and cry emanating from there. The PW has emphatically testified that he had seen the accused Raju Satnami coming out of the room armed with a machete which was laden with blood. Although he did not see the actual act, but he was the first person to reach the place of occurrence, as his room was situated in front of the room where Onima Mehra was hospitalized and treated. PW4 further specifically testified that he saw cut injuries on the neck of Onima Mehra, from where plethora of blood was oozing out when he reached the room. He found Onima Mehra dead on examination, as by that time she was succumbed to previous injuries sustained in a vital part, that is her neck. This piece of evidence has been substantiated by PW8, who saw accused Raju Satnami coming out of the room armed with a machete. PW4 and PW8 were present at the aforesaid place of occurrence. As such, they were the first person to reach the place of occurrence after hearing the sound of hue and cry emanating from the room where Onima Mehra was treated. PW4, PW7, and PW8 had categorically testified that the accused persons and the deceased had quarreled over sharing tap water in their locality, which took place in the early morning on 5/9/2030. Being the state employees, the aforesaid PW knew regarding the fight that took place between the accused person and the family members of Onima Mehra. This piece of evidence has been authenticated by PW1, PW2, PW3, and PW5 to the extent that Onima Mehra was hospitalized due to the injury sustained by her. They had again in unison testified that Raju Satnami had assaulted her on the head with a bucket. As a consequence, she has sustained injuries on her head and she was rushed to the TE hospital for medical treatment there. All the aforesaid witnesses have again testified that they heard that the accused Raju Satnami went inside the room of the hospital where Onima Mehra was being treated. They again corroborated the evidence of PW4 and PW8 by testifying that they had seen Onima Mehra lying in a pool of blood inside the hospital room. They have also seen cut injuries on her neck from where plethora of blood was oozing out. Therefore, circumstantial evidence present by the PW has corroborated the evidence of PW4 and PW8.
Just a
They had again corroborated the evidence of PW 4 and 8 by testifying that they had seen Anima Mehra lying in a pool of blood inside the hospital. They've also seen cut injuries on her neck from where plethora of blood was oozing out. Therefore, the circumstantial evidence presented by the PWs have corroborated the evidence of PW 4 and 8, culminating in the establishment of prosecution case beyond all reasonable doubt. The evidence of aforesaid witnesses has given suit in the arm of prosecution case when the medical officer has opined that he found cut injuries on the neck of Anima Mehra, and as a result, she died due to excessive bleeding. The prosecution case again reached the zenith when the investigator found a dead body of Anima Mehra lying in a pool of blood in one of the rooms of the hospital. Paragraph 29. It has again protruded from the evidence at hand that the accused persons had assaulted Anima Mehra 5/9/2013 at 6:30 a.m. in their locality where water tap was situated. It is surfaced that the deceased before her death had stated before her family members that PW1, that is PW1, 2, and 3, the accused Saju Satnami had assaulted her with a bucket, as a result of which she sustained simple injuries on her head. This piece of evidence has been established by PW4, who had categorically testified that Anima Mehra was being treated for simple injuries on her head and she was kept for observation at the aforesaid hospital room. Paragraph 30. From the extrajudicial confessions made before her family members, it has precipitated that she had categorically named accused Saju Satnami, remaining accused persons who assaulted her in the early morning near the water tap due to outcome of a quarrel between them. If the evidence about extrajudicial confession comes from the truth mouth of the witnesses who appear to be unbiased, not even remotely inimical to the accused, and in respect of whom nothing is brought out which may tend to indicate that he may have a motive for attributing an untruthful statement of the accused, the words spoken to by the witness are clear, unambiguous, unmistakably convey that the accused is the perpetrator of the crime, and nothing is omitted by the witness which may militate against it. Extrajudicial confession can be accepted and can be basis of a conviction in the case of so and so. In extrajudicial confession, court should require the witness to give the actual words used by the accused nearly as possible. That has been reported in so and so. And thus the court has cited so many cases. Thereafter, there is no rule that extrajudicial confession is not to be accepted if the witnesses give the substance of it and not the actual words. It is the substance of the extrajudicial confession which really matters. Confession, if oral, must be assessed carefully and voluntarily. Nature of confession must also be considered before it can be acted out. Extrajudicial confession must be proved by evidence of the most reliable. Paragraph 31. The extrajudicial confession are those which are made by the party elsewhere than before a magistrate or in court. The evidence of extrajudicial confession in the very nature of the things is a weak piece of evidence. It would depend on the nature of the circumstance, the time when the confession was made, and the credibility of witness who speak to such a confession. Para 30. The extrajudicial confession should be proved in the same way as other admissions or statements by the evidence of persons to whom they were made or who heard them made, or by the documents, if any, in which they were recorded. Like judicial confessions made before a magistrate, an extrajudicial confession may also be obtained by coercion, promise of favor, false hope, etc. It is the further infirmity that in most cases, owing to the absence of writing, the exact words by the accused cannot be known, and witness may have misunderstood or may not have remembered or reported accurately. For this reason, extrajudicial confessions are not considered of much value unless the witness reporting can be dependent upon from all points of view and the acknowledgement of the guilt is clear and unequivocal. Para 33. As all the accused persons are found guilty under section 323, 334 of IPC. So far, section 147, 148, and 149 are concerned. It has emerged that the allegations of rioting armed with dangerous weapon have not had all been.
Just a moment.
That's all. Then she was.
Submission of one, submission disability.
Para 33. As all the accused persons are found guilty under section 323, 34 of IPC. So for section 147, 148, 149 are concerned. It has emerged. The allegations of rioting armed with dangerous weapons have not at all been propped up against the accused person. There is not a single witness has testified that they have seen the accused dead Mehra Boneta. So allegation of forming an unlawful assembly has not at all been protruded against the accused person due to lack of hard evidence in this regard. At best, they can be booked under section 323, 34 of the IPC as common intention to harm Anima Mehra has been surfaced in evidence. Para 34. From the scenario of the sequence of events leading to the facts and circumstances of the case, it points towards the fact that the intention and motive on the part of the accused, Raju Satnami, is predominant, as it seems logical that the accused has murdered Anima Mehra due to enmity that existed between them relating to sharing of tap water, which has also been hinted by the eyewitnesses as well. Even a murder case, the real evidence against an accused may consist of only one witness. However, the evidence of witness alone nonetheless is sufficient to convict an accused if that evidence establishes his guilt beyond reasonable doubt. In this context, the court has consulted the rulings as quoted here and now. Para 37. So for accused Raju Satnami is concerned, it can be said that eyewitness accounts of PW4 and PW8 and the circumstantial evidence protruded against the accused are capable of any explanation other than the one proposed to be proved that the accused is the person who caused death to Anima Mehra. The defense pleas are further sustained resolved when PW10, that is the investigator, has testified in a consistent and coherent manner by substantiating the chain of sequence of events leading to the incident. It is evident the investigator has done a commendable job by virtually demolishing the pleas of defense, thus establishing the case of prosecution by leaving behind no reasonable doubt at all so far as the accused Raju Satnami is concerned. This is totally my lord, asserting my lord. The trial court has my lord stated that commendable job has been done by the IO. What commendable job has been done, my lord? He doesn't my lord, make an attempt to recover the weapon of offense, my lord. Page 39, para 39. It has been repeatedly laid down by Honorable Supreme Court of India and by other high courts in many cases that a conviction can safely be based on circumstantial evidence provided several circumstances relied upon by the prosecutions are established beyond doubt that the incriminating facts are such as to be incompatible with the innocence of the accused and incapable of explanation on any reasonable hypothesis other than that of the accused's guilt. This principle is enunciated in the decisions of Supreme Court in Hanuman versus State of MP and so and so, and there are other cases that has been cited now. And in the decisions of Mysore High Court in Saura versus Government of Mysore and other case. Para 40. When a case has to be decided on sole evidence of an eyewitness as well as the circumstances of evidence, then a duty is cast upon the prosecution to establish all the circumstances which will form a complete chain of pointing to the guilt of the accused alone and not any other hypothesis. In the present case, my lord, there was no proof of any chain of circumstances so far the present appellant is concerned. All inconsistencies, discrepancies are brushed aside, my lord.
Mr. Take care.
My lord.
Just long and short of it.
My lord.
This, insofar as the other appeals are concerned, we are inclined to allow that by convicting them of offense of 323. But insofar as the first, this appeal against Raju is concerned,
Yes.
we have our own reasons, but he is not entitled to any benefit or doubt. And against him, the insofar as the accused number 1 is concerned, this Raju, against him a case has been made out for having fatally assaulted the victim. We will not be very happy with the language used in the judgment. But we have a reasons to hold that he is at least guilty. So appeal we think we will be allowing for this the other family members of assaulting because this when 34 is used, the overt and covert act by the other accused persons to have that assault, that is missing.
Overt act is not required. If I can show the common intention.
No,
Overt act in both 149 and 34 are not required. If we can show common intention or the object.
no, you see, she was assaulted with a bucket.
That too,
So-
only Saju.
In the morning, my lord,
So
6:30.
therefore, you see the family members, this, you can't implicate the others just by using 34.
Mm.
The common intention to assault her was never there. But this is not a usual, what you call, it's not an unusual quarrel.
It happens over water, they fought. And then
Every time
ladies
they-
fought. Perhaps Saju got agitated, Saju came and gave a.
Raju was not there, my lord.
Raju
The
was
early
not
incident
there.
was
No,
taken.
Raju was not there, but the assault part. There
Huh.
we are of the view that he is guilty of the offense. We'll give our own reasons. But evidence against him is, I think, complete. Chain of events leading to conviction of the Raju for murder. That is complete in itself. The doctor having seen it, there is one. Although you have strenuously made the effort to show us the evidence of others, but you see what has happened is in the cross-examination, the evidence of the PW4 has not been demolished, number one. Second is that when the IO was examined, the corroboration, what do you call the discrepancies could not be elicited from him.
Contradictions.
The fact that he gave a statement that in his examination in chief, that the Raju told that he had thrown the dao. Even to that extent, it was never asked in the cross-examination. So therefore, that piece of evidence becomes a clinching evidence when he is not cross-examined on the point. If you can, these are the two things. Eyewitness saying that he was out with the blood, he was not cross-examined. The other witness who saw the dao going out with a dao in his hand. Even he has not been cross-examined.
And what he said is, I did not notice whether there
I
was
did not
blood,
notice.
blood or not.
I did not notice.
He did not say that there
One
was no
says
blood.
there is a blood in the dao, right?
It's okay.
The other says no, there is no blood.
There
He
is
saw
no,
the
he
dao.
did not
He
say
did
there
not
was
notice.
blood in the
He did not,
he
she's
did
right.
notice
The language is she did not notice.
whether there was blood or not.
But
There's
in
a
cross-examination, it was, you see, that could not be disproved.
May I read that?
Yes,
Once it-
please,
Page
by all means.
Page 20, well,
Mhm. You read, that's something we have seen.
page 20. And know the accused Raju Sarnam.
No, please the last part.
Hmm.
Only the last part he says.
I was attending to the patients and then I went to the pharmacy and saw Raju going outside with a dao. I did not notice if
Notice.
there was any blood in the dao. He did not say there was no blood. There is a difference between the statements.
And that part was not cross-examined, to
That
make it
was the-
clear.
Cross-examination not done by properly. Present.
So he won't make a comment. But still that is not there. So therefore, we are saying that there are two clinching evidence by which
But so far, my lord,
you have not been able to be convinced.
recovery of weapon, my lord. This one I
That is
put
not
my-
fatal. You can show us any judgment, any court where it says that with the evidence of IO, when he gives an explanation that he was thrown in the river, then you show us any judgment. I don't think there will be a judgment which says that it will be fatal.
May I show one judgment of this one?
Yes, yes.
By Justice Omita Oberoi and A.K. Goswami, my lord.
Mhm.
Reported in 2011, 4 GLP 153.
Yes,
my lord. I have already given the book. The headings of the my lord. Heading reads says my lord. Appellant alleged to have killed his brother by hacking him with a dao in the neck. PW1 had stated in the Azahar that he was informed by his elder brother and the accused about the incident, and the accused had confessed his guilt to PW5. The investigating officer has deposed that the dao, spade, etc., was recovered from the jungle at the instance of the accused. The accused, in a statement made under 1313 CRPC, had deposed that he had thrown the dao, spade, etc., in the jungle and confessed his guilt under the pressure of the police. Help. Conviction cannot sustain due to the lack of impeccable evidence against the accused number one.
Okay, because it's a case of confessional statement.
My lord.
See, in a confessional statement, it has to be corroborated. The statement itself can't be a placing evidence unless the facts are proved.
Where 12, 13, 14 are imposed. 14, 12, 13, 16 and 17. May I read those paragraph? Paragraph 12 of the judgment.
You
Page,
see, here, you see, you don't have to read it. Para 13 says
my lord.
that the dhow was recovered. He gave a statement that the dhow was thrown in the jungle,
Right.
the dhow was recovered.
Right.
But thereafter, this dhow was never produced before the court because it's a evidence which is available.
My lord.
So you see, evidence
In
available.
the instant case, there is no endeavor was made to recover it.
No, it's not
Even
that.
there is no mention. as to
There is an
which place it
explanation.
has been thrown, my lord.
There is an explanation that it was thrown.
My lord.
And therefore, in a river, he did not take the trouble of diving in the river.
At least, my lord, I should have.
You show us on the facts
My
that where the weapon of assault is unretrievable. Then also it is fatal. It will never be fatal. Here is a conviction based on confessional statement. It stands on a different footing. You tell us a judgment where it says that confessional statement, you see, must be believable. It must be corroborative of the fact that there was a murder.
Right.
And then if there is a corroboration which is terrible on the basis of a confessional statement, it becomes a clinching evidence. But if the other facts are not proved, confession itself can't be an evidence to punish someone.
That's true. my lord. In the instant case, my lord, one thing is important, my lord. Both the families are admitted in the hospital, my lord. Family of the Raju and the family of the informant number 1, Solomon Sabna. And the Raju was not there while the earlier incident was taken place at 6:30 a.m. on that day. And nobody has seen Raju coming to the hospital, my lord, with the towel. But 2 witnesses say that they have seen he is going out, my lord. The same is not complete, my lord, in this case, my lord. One Shyam Paik, my lord, he informed me initially that the incident was taken
something
place.
which
He
is
was
not-
not examined
you
in
see,
this case,
Behavior of a person who's not an intentional witness can be said.
my lord.
There's no fixed rule. Because you see, let us take me for an example. I would be a very bad witness. You see, just turn around, your friends sitting behind. If you ask me, sir, that you were facing the door, did you notice when X came into the courtroom and sat down? When the second lawyer, he came and sat down? When the third lawyer came and sat down, did you notice him? It was not my business to notice. If I did not notice, there are a lot of your friends behind. Just look, maybe 20 of them sitting, and 20 of them I had no business to record their presence, and therefore I did not notice at which point of time they came into the courtroom. But yes, you have argued when you are going out. I may notice the time and say that yes, Mr. Saikia, while leaving, it was 1 o'clock. Because you were arguing before me. I have a business to remember that who had argued.
That's why
But 20 of your friends are there. I don't remember anyone coming in, sitting. At what time? Somebody asked me, at what time did they came in? And you are watching them. I am facing them. But I never recorded their presence. It's a ready example I am giving it to you.
that's true, my lord. That's true.
You won't notice. It's not a business to notice at that point of time, but some incident happened. Then you remember, oh, yes, I saw him going out.
And one saw with the blood, thou with the blood, and another saw only the thou.
Is it unbelievable? That's what you'll have to demolish. That you have not been able to show. Non-noticing of a fact.
And nobody has seen my lord Raju coming to the hospital.
It's okay. It was no. I just told you my example. There are 20 of your friends sitting behind. Was sitting behind you. I would have noticed when they enter because both the gates are in my front, but I never noticed.
And the best evidence, my lord, one Shyam Paik.
No, but you see
So that's
something,
okay, my lord.
some incident happens, and now somebody is running away from the courtroom. Then I would remember, yes, I saw him running away. But if you ask me a question, Your Lordship, did you see that man coming in? I never saw him. Although you are all in my presence, and vision. I've never noticed you are coming in.
My submission, my lord, the best evidence. my lord.
No, will it
Stamp
be
pipe.
fatal? Will it be fatal? Suppose
That
you
will
can
be fatal, my lord. He is the person who informed you, my
No,
lord.
no. If something is, some incident happens here and somebody I saw running him out, whether that evidence can be demolished merely because I have not seen him coming in. That is the question I am posing you. Some incident had happened and somebody is running out.
To my
Let me give an example. It may be an inappropriate example, but still I am giving that example. It's only an illustration. I'm not casting any aspersion. You dislike the statements which I am making because I am not considering to what you have argued. And suddenly you throw your pen at me. That is the available thing which is available to you, and you throw it to me. Or let us say you're not you. Somebody your instructing counsel is sitting behind you and he throws a pen at me. Give an example. Now, I may not have, although I am hearing your argument, I may not have noticed the second lawyer who is sitting behind you. But when he has thrown that pen, then I notice him. That yes, he is the man who has thrown something at me. And then the lawyer walks away. I notice him walking away. Now, will that evidence be impeached merely because I never noticed him coming and sitting behind you and you are making the argument? Tell me that. Answer will be no. The evidence won't be impeached merely because I have not noticed somebody coming in and sitting behind you, sitting beside you and arguing, because I am concentrating on your argument. I may not have noticed somebody coming and sitting beside you. But that was not the intention of the court. To see someone coming in, going out. I am not taking up attendance of the lawyers in the courtroom. Therefore, I am not required to notice that. The ward boy or the doctor, they are not in business of recording presence in the hospital. They will not notice. Yes, you could have said that yes, a man was in the guard in the hospital. There was a guard.
Sokidar was. He
Yes.
informed him.
No, it's okay. And that guard did not notice him, then it's okay. But you did not call for a defense witness.
Sokidar was the best witness, my lord. He
No,
was
no.
not examined in the case. They have withdrawn that. Sokidar was Shyam Pai.
No, but you could have called him as defense witness. You could have called him to disprove that, but it is not done.
The FIR itself disclosed that Sokidar has informed Shyam Pai. He should
It's
be
okay.
a witness in the, my lord, of the prosecution, but he was not examined at all.
No, he was not summoned as witness. This is my two. Basically, I'm not convinced on that Raju.
At best, Lordship can bring it down because there was a quarrel. There was
No.
there was no mutual fight.
No. But a
Provocation.
subsequent act of going there and then assaulting.
Too brutal in the
No,
hospital.
not that. You see, that's a cold-blooded assault because it's not a spur of the moment. Therefore, it's not that there was a spur of the moment he got angered and killed. Because he went to the hospital and then severed the head,
Two injuries.
2 injuries.
But his family members are also there admitted. And then there was some provocation. I can stretch it and have to stretch it.
Grave and
But
sudden provocation must be in the spur of the moment.
it has to be
You
sudden.
will not
and
be able
brave.
to. You'll not be able to convince us that
Mm.
after even 10 minutes, if somebody says that the spur of the moment.
Because
my lapse of-
Nanavati, as we know that case, he went and brought the pistol. So he had cooling period time. Here also incident had happened in the morning, 6:30. And this had happened after 1 or 2 hours. So the
7.
cooling
Doctor says 7.
cooling period was there. But Raju was not there. Raju perhaps had come to know immediately and he came, can happen. At 2 o'clock.
My lord. Yeah, regarding my lord, circumstantial evidence, my lord. Two thousand. Well, two SCC, my lord. Page 788. Page 788, my lord, in case of my lord Shanmugam versus state of Kerala, my lord.
122788.
2012, 2 SCC 788, my lord. Para 7.
Yes.
We take up for consideration the last submission made by the learned counsel for appellant. We are inclined to agree that when a case is sought to be proved by a prosecution on the basis of circumstantial evidence, the burden of on the prosecution is that it must prove its circumstances in such a way as to complete the same, and at the same time should be consistent with the guilt of the accused. Any reasonable doubt in proving the circumstances must be resolved in favor of the accused. This is important. Any reasonable doubt in proving the circumstances must be resolved in favor of the accused. The accused must be given the benefit of any fact or circumstances which is consistent with his innocence, which is to be presumed unless the contrary is proved by the chain of circumstances.
Yes.
This is my 2012 2 SCC. 2009 9 SCC, page 152, my lord. That is a case of my lord, robbery and murder, my lord, para 10 to 13. Very, very important, my lord, regarding circumstantial evidence. Page 10 of the para 10 of the judgment.
2000
2009 9 SCC
152.
15. In the case of Panier versus state of Tamil Nadu. There was a case of my lord, robbery and murder, my lord. Paragraph 10 to 30, my lord. May I read, my lord?
Just wrong. Para
Para 10 to 13, 30, 30. May I read? Para 10. We'd like to take up the first circumstance. The witness, Allah Swami, PW4 in his evidence very clearly admitted that he was not on talking terms with Chilanga Valley who was none else but his own sister. At a time when he saw the accused, he, Alarasamy, was accompanying his real brother, namely so and so. The prosecution did not bother to examine Ramaswabu, though his statement was also recorded. In the present case also, Shyam Paikman, who is the viral witness, he was not examined. Para 11. It has come in the cross-examination of PW4, Alaraswamy, that he attended the funeral, though he was on cross terms with the family of the deceased during the whole funeral. The accused was actually present. What surprises us is that in spite of this witness did not say anything either to Subia, PW1, the husband of Chilagawali, or even to the police, and his statement was not recorded for a good long 3 years. Now, if the witness had been seen, the accused, following the Thalivali, Chilagawali, he also knew about the violent death of Chilagawali and had seen the accused at the funeral. One wonders as to why the witness kept quiet without telling it to anyone, as if this is not sufficient. Krishnaswamy, PW13, the investigating officer, was specifically asked the question as to why these witnesses, namely so and so, PW4, one Perulamaswamy and Ramaswabu, were not examined by him. The investigating officer was admitted that he could not give any reason for not examining any of these witnesses on the same. Para 14, my lord, and ordinarily we would not discuss the evidence in our appellate jurisdiction. However, when it is found that the crucial circumstances have escaped the notice of the appellate court or the trial court, this court will consider the evidence lest any injustice is caused. In our opinion, the evidence of Alaraswamy, PW4, should not have been believed. This takes care of the first circumstance. Para 15. The second circumstance is, of course, the recovery of ornaments from the accused. In this behalf, we must go back to the evidence of Subia, PW1, who in his first information report has mentioned that both the R of the studs of Chilagawali were missing from her body. We have seen the original first information report where there is a clear reference to a pair of R studs. When we see this evidence, here also Subia, PW1, spoke about both the R studs not being available on her person. It is the prosecution story that after his arrest, the accused confessed that he has sold the R stud in the shop of Shankar, meaning thereby as if that he had removed only one R stud and remaining R stud remained with the dead body. When we see the inquest concernum exhibit so and so, it apparent that there was one R stud on the body of the deceased. Therefore, this gives a shattering blow, firstly to the evidence of Subia, PW1, and secondly to the credibility of investigating agency. As if this is not sufficient, when the accused was arrested about 12 days after the incident on so and so, he is said to have confessed that he sold one R stud in the shop of Shankar, PW6. Para 16. When we see the evidence of Shankar, PW6, it comes out that witness said that the accused had come to sell an R stud, but he refused to buy, as it was only one piece of R stud out of pair that the accused had offered to sell. He therefore says that he gave one pair of R stud to the investigating agency, which pair ultimately has come up before the court as material object. So and so. This gives shattering blow to the very credibility of investigating agency, as obviously the pair of R stud seems to have been seized from the shop of Shankar, when the case of the prosecution is accused has sold only one R stud, the other R stud having remained with the dead body of Chilagawali. Para 7. In his cross-examination by the prosecution, Shankar, PW6, was made to say, when the accused came, he brought one seine and that he would buy the said seine, as it was his business only to sell the ornaments, not to buy the seine. The witness is also very significantly identified the seine being material object. In his cross-examination by the defense, he candidly admitted The material object 7 series was his property and there was a number of saints like 5, which is a common ornament. He also owned up that he could not give any specification of the saint, as there could be so many with design saints like the saint concerned. The other witnesses on the discovery has not been examined. It is therefore obvious the theory of accused having stolen one art stood of the Chilaga Valley and then he's having sold it in the shop of Shankar is a might. And we are also amazed with the attempt of the investigating agency to replace a pair of art stood in place of one art stood concerned. In fact, his examination is in chief, PW6 said that he was called to police station and peak hours. He gave one pair of hours. He also identified the same, and there is no question put on the subject of ours to the instance of the prosecution. It is therefore obvious that the theory of immediate possession of the ornaments of Thilagaon Valley, at least so far as it relates to the art streets, must fall down. The investigation has not been fair in presenting the pair of art stood as if those art stoods were recovered from the accused. This takes us to the other two ornaments, namely gold saint and the Thali bow weighing 3 over sovereign. They are material object number 5 and 6. As the prosecution story goes, those ornaments were given by the accused immediately on his arrest near the dispensary of so-and-so. PW7 has been examined. It does not support either the event of arrest or the
Mr. Sakia, we are not discouraging you from citing as evidence,
Mailer.
but have you gone through the LCR or not? I don't know. You see what has happened. In the FIR, this person, what is that name? Payak.
Siam Pai.
He was not introduced in the FIR. He's not introduced even in the statement made under 161 CRPC. Therefore, you see, when he gives a statement, which is an improved statement in the in that evidence in chief, you don't cross-examine on the point. No,
He
the
was
witness.
never examined. Siam Pai.
No. The complainant,
Mailer.
he gave that statement out of the blue in the examination in chief, but he was not cross-examined on the point. No other witnesses you have cross-verified, or in the IOC you did not cross him for the contradiction about the existence of that pack. So therefore, no amount of judgment you show us on non-consideration of the evidence of why the statement of pack was not recorded would not influence us. You see, the fact is that if the police had, during course of investigation, if you can show that all the witnesses gave the statement of that Mr. Payak was present, then I could have understood your argument that the non-examination of a vital witness is materially affecting the trial. But merely because a name has come up in the examination in chief, which remains uncorroborated, no amount of judgments you show. It's not only one. You may show us 10. But the distinguishable point is only one. That during course of investigation, there's nothing before us to show that the police knew about the existence of Payak. So therefore, you see, the principle is number one, I can take presumption of what is present. If it's a negative presumption, the evidence act says of what items I can take a negative presumption. So therefore, if this witness is never, this person is not introduced anywhere, then please tell us how can we arrive at a finding that the IO did not examine him
Well, I'm trying to raise before this honorable court.
No, it's,
That
you
nobody
see,
has seen the Raju Satnami to come to the hospital, my lord. But only they have, the two
Hmm.
witnesses seen, they have
no, you show me
seen
any
the
authority
accused
where
going
that,
out of the.
you show me any authority.
Right.
That is a, that is federal for the prosecution. Because you are citing the judgments, so there's 2000, the present judgment you were citing
My lord.
was on a point which I am saying that is not relevant. And you, although you are citing a judgment, but it will not influence us because of the fact, and why I have disclosed you why it's not influencing us. Unless this Paik was before the IO and they did not examine him. The case you are citing is totally different.
The other suggestions, my lord, I have given my lord,
That's
all are
okay.
circumstantial.
That's okay, but because you see, this could.
As there is no, my lord, the same is not proved, my lord. Right from coming to the hospital, my lord, then kill the accused, then going out of the hospital, my lord, by the HPF. That was not proved by the prosecution.
No, you show us any authority where any court has given a negative finding or has discounted the evidence merely because nobody saw the entry. Because then you see every theft case will fall. Because when somebody comes stealthily and then enters into a house to commit theft, nobody saw him entering. So therefore,
Well, it is the case of the my lord, prosecution to
no,
prove the case beyond.
no,
reasonable
that's
doubt.
okay. Just tell me the sequence. If nobody saw, then how do you prove a theft? That means if I agree to your submission,
Fine.
then every case of theft will fall.
Well, once the stolen property recovered from some custody, my lord, it proves, my lord. Prima facie proves that he is the.
No,
person
even
who
if you
committed.
see, even if that is not true, but
That is-
somebody saw him jumping out of the house, running away,
My lord.
and then he's caught without anything. You see, in a bus, everything that happens in every bus. If you have traveled with a bus, because I still travel on a city bus.
Right.
You see, there's a pickpocketing. The purse which has been stolen, it's passed off to third person much before that. Then somebody finds that the purse is not there, they shout. And one person is caught because there are experienced people traveling in buses and trains who know that he is a thief. He's a pickpocket, known pickpocket. They catch him, find nothing. Because the purse has already been shifted away. But yes, those people are prosecuted. And at times they are even persecuted, what you call, with conviction, when they can prove the chain otherwise. So you see, entry, it's very hard to accept your argument that if entry is not seen, the crime is not proved.
That is my case. The chain is not proved completely. It is not that the house of the accused is by the side of the
No,
hospital.
that is your argument, but I am questioning you that whether that is a sound principle to
It is-
decide a criminal.
It is not the case that the house of the accused is by the side of the hospital, my lord. The victim was taken through a ambulance, my lord, 108. My lord. That means there's some distance between the my lord hospital and the accused, my lord, as well as the victim, my lord. Victim's house is the adjacent to the accused house. My lord. Someone has to see the Raju coming to the hospital, which is Dow, my lord.
In a
There's
garden
not-
hospital at 7 a.m.
My lord.
In a garden hospital at 7 a.m.
Same 7 a.m. as a peak
People-
time, my lord, for
people-
the person going to the work, my lord.
No, it's okay, but hospital.
My lord. Hospital is between the garden area, my lord.
I understand, but you see, you have to be reasonable.
This is my case, man. Nobody has seen my. There is no witness coming, seeing the accused coming from the which had Dow, my.
Don't bother about that. You see, you came to the court
My lord.
in a city of Guwahati which has a population of 15 to 20 lakh. Please tell me who might have observed you coming out of the home, coming to the court. In a city of 15 to 20 lakh population, nobody watches a neighbor. Where he is going out, where he is coming out. Do you keep track of your neighbors also? When he's coming in, when he's going out? No. In a city, we don't keep a track of people.
But in a garden, this situation
No,
is
no, no,
something
no.
different.
They're not possible.
Since the house of the accused and the
No,
victim
no.
are
It
adjacent.
is for it was for the defense to prove that in a garden, everybody knows about everything. And then it's not possible for one to enter into the hospital without the garden people knowing it. You should have led an evidence to that effect. An inference can't be drawn that if in a tea garden somebody did not see the entry, there's no crime. That presumption is not available under the Evidence Act.
Since 7 AM is the peak time, 40
No.
persons.
I don't know it's a peak time.
Peak time.
I've never stayed in a garden. I don't know it's a peak time. You convince me it's a peak time. And that has to be by way of an evidence. You should have introduced it in the evidence that at 8 o'clock, people by habit assemble in the garden at 6:30 to 7 and they remain till 8 o'clock. That is an unusual, what you call presumption you are asking us to take.
It's not
How can I take a presumption that in a
Because we have
garden?
seen from layer mine.
No. You see, please give us a reason to believe that.
There is no
presumption.
evidence, there is no, my lord,
Then,
statement in the.
then. In the court
But
at
it is
10,
unbelievable,
no.
my lord, nobody has seen, my lord.
in a court,
It is coming with a doubt.
just tell me, Mr. Sagia, today at 10:30 when you entered the court, which are the lawyers you saw entering a court at 10:30 AM? Just tell me, it's a peak time at 10:15, every lawyer enters the court premises. Just tell me how many lawyers you have watched. We have 3,000 lawyers registered in the Guwahati High Court Bar Association.
In the instant case, my lord, there is a history, my lord. At 6:30 AM, my lord, there was a fight between these two families, my lord. After 20 minutes thereafter, my lord, the incident was taken place.
So therefore you should have proved that after the incident in village, in that tea
And
garden.
all people are,
No,
my
no.
lord,
I understand.
alarmed.
Please, you should have introduced the evidence that in this particular tea garden, whatever incident happens, all the villagers rush to that place, they follow the accused, they follow the victim, they keep a track of everything what is happening, and that is a custom which is being followed for last 1 year in this. There was an earlier case also when people kept track.
There is no evidence on that.
So you have also not introduced it. Say in an appeal, to take that into consideration will be preposterous. Can an appeal be decided on that ground that maybe nobody saw coming in? Will they disprove a crime? There are three things in section 5 of the 3 or 5 of the Evidence Act. One is proof, one is not proved,
Yes, true.
third proposition is disproved.
Yes.
So you show that your statement falls within any of these three exceptions. Three propositions.
Yes.
By any case law, that entry, if it is not seen, that it disproves the crime. That is something which will be otherwise preposterous.
My lord, that the another circumstance, my lord. There are allegedly two eyewitnesses. I am repeatedly.
Let me tell you one simple question. You see, let us take a small example. In the bar room, in your table, there are 3 female lawyers who are also keeping their goods, their bags. Now, let us say an extreme example that you are wanting to pick up this pen and your hand enters one of the bag. Just this extreme example. It will not happen, but still the hand somehow enters the bag. Now, the question I'm asking you is whether the touching of the bag itself becomes an incident of theft, or if something comes out, it becomes when something is displaced and it is taken into your custody, then it becomes a theft. And then in that circumstances, if in the bar room nobody saw you entering into the bar room, then whether that will be a disproving of the crime. If at all this pen has been taken out of that bag. It's a simple example which can happen in any table. The entry into the hand, displacement of a pen, and no witness to see you entering the bar room. Now, how do you see that? Because it's a fact accompli. Once something has happened, it's a fact that has happened. So after that, whether the entry into the room is required to be proved, no.
But here in the case, my lord, there is evidence that there was nurses, doctor, and the ward boy was there. Nobody has seen. That is something, my lord, suspicious.
Unless they were not
Nurses are
performing,
there, my
it's
lord.
okay.
Ward boy is
No,
also
it's
there.
okay.
The doctor is also present.
You see, I'm asking you these questions for a simple reason, because I have had experience in entering into the hospitals. If a nurse and a ward boy is keeping a watch on people who are coming and going, then they are not taking care of the patients. They will be taking care of the patients. They will not be there standing, looking at you, whether one person is coming or not, who is going out. If that is his business, then he is not a good ward boy or a doctor or a nurse. They
But
will be
they are
attending to the
treating-
patient.
they
You
are
see,
treating-
no, Mr.
They are treating the victim and the other person.
No, you see, one becomes attentive when they see a crime, when they see a halagulla, then they rush and see what has happened. Then they see somebody running out,
My lord.
and then they just imagine. You see, in a bar room, I just gave you a statement in the courtroom. There are lawyers entering, 20 people are there, lawyers entering and going out. I don't keep a watch on the lawyers entering the courtroom and going out. But yes, if some incident happens in the courtroom and I see you running away from the courtroom, then I'll give a positive statement. Yes, I saw Mr. Saikia running away after this incident happened. This book fell and then he ran away. So unless I see this book falling in the ground and making a sound, disturbing the courtroom, and you running away, your entry is not something which is not required to be visualized by anybody in the courtroom. Nobody in the courtroom would have a business to watch you when you enter in the courtroom.
That is true, but it is suspicious. In presence of nurses, doctor, and ward boy, none has seen my. This is suspicious. That was not proved.
It's not acceptable.
Because it is-
No matter how many citations you give, but it is unacceptable. Because just because somebody did not say the entry, the crime did not happen. What happens to the evidence that they saw you with the dao? That has not been disproved. One saw you with a dao with a blood stain. That is not disproved. The other saw you with a dao, did not notice the what you call the blood. That is also a fact is not disproved. That in the scene of crime you were seen with a dao in the hand. And even if I accept your submission, I'm saying I because my sister will not accept it. Even if I accept your submission, to the effect that in the garden people are used to carry dao
Yes.
at any point of time. But you see, this dao is not being carried as in the hand like this. If you are carrying in a village and you are carrying a dao or any what do you call the equipment of agriculture, you are tucking it somewhere. Dao will be in the in your what you call this gamasa or somewhere. But this dao is even in a village is not carried like this. That they will not walk like this with the dao in hand. Agricultural implement, they will have spades, they will have everything, but they don't carry it like that in a manner you are assaulting. They may carry it like this. All in all, hull. You carry it like that. It's not that I have never seen a village. I may not have lived there, but I guess I have seen a village. People would not be carrying. And especially in a hospital, it's not disproved. It's not disproved. And it's not a culture to enter into a hospital with dao readily available in the hand, or walking away from a hospital with the dao in the hand. It's not a usual behavior.
Still is a tea garden hospital. It's not a civil
No, I
hospital.
understand. It may be anywhere. It may be anywhere. It may be heaven. It may be hell. But to carry this,
Time is the peak hours, my lord.
huh?
Time is the peak hour. Time, my lord. And so for
Yes.
other accused concerns, my lord, there is no,
And this other citations are what point,
no, only regarding my circumstantial evidence. When circumstances is not proved, the chain of circumstances is not proved, my lord. Conviction cannot be based, my lord.
This 2011, 12 SCC 56, 2012, 2 SCC 399, 2012, 4 SCC 107,
All are regarding
2012,
circumstances.
all are circumstantial evidence. You may give us a copy,
You can supply.
just mark those paragraphs. Yes, Ms. Jahan.
Like the chain of circumstances of the entire case,
Yes.
I mean implicating even the relatives. from the initial incident till the killing of the deceased. Now, I'll just cull out the chain of the circumstances, and I humbly submit that the chain is complete. And I can see that there is no a break in that particular chain. Now, the first chain, first circumstance would be 6:30, there was a fight. And the sister saw it. Sister PW2, who had come out by then after hearing hue and cry, she came out and she saw all the three ladies hitting the mother. She did not speak about Saju or Raju. Raju was not even there. Saju, she did not speak of. She said Dimbeswar, that is Gauri, Dimbeswari, Gauri, Bina, and Sunti. All three had hit her. Then she was also hit. She said, I was hit in my hands. Then mother goes back to her house. PW1 was inside. PW1 said mother had come, told him that Saju had hit her with a bucket on her head. Then the PW1 takes her to the hospital. Then in the meantime, PW2 goes and informs her father. That is there in the evidence, Lordship has already seen. PW2 went to inform her father, who had gone to some other place. Then they both came and they went to the hospital. PW2 is very clear in saying all this, that me and father came back and then we went to the hospital. In the hospital, mother said that Saju had hit her on the head. That is there in the statement of PW2. Then PW1 and PW3, 3 is the father. PW1 and 3 went to the VDP, spoke about, told him about the incident. VDP, I think, is PW5, although it doesn't write as VDP secretary, but then he said, here, it is not written, he is the VDP secretary, but then he said that both of them came and informed me. PW3. Lordship will see, because this makes the entire story plausible and believable. PW3, he said that Somu came. PW3 is the father. PW5, he said accused person had a fight with Somu over water, so she is a wrongly typed. So he had come over to me and I asked him to file a case. So this chain continues. He told the father to file a case. Then father and the son goes to the police station and they file the case. Somu, somebody else writes the FIR. Somu has put his signature. And when Somu said, PW1 said that when they were in the process of writing the FIR, he got a call from the Chowkidar that mother was killed in the hospital. Then they go to the hospital and they find they were not allowed to sit in initially, and then they find their mother dead. And then, Raju killed, and PW4 called and then what had happened, PW4, the doctor, when he saw the accused going out, doctor called PW7. PW7, he called him, PW7, and informed him that Raju killed his mother. There was an altercation. Both parties were admitted in the hospital. They were injured. And this was informed by PW4 to PW7. PW7 informs the police about this. And then the Kalyan statements, PW4, he saw him. And this is not remote. This is not after long. This is at 7 o'clock, 1 hour. Not even 1 hour. In the process of taking her to the hospital on all, half an hour must have gone. 6:30, she reaches the hospital. 7, this incident takes place. And 7, he saw the accused going out of the room with her dow bloodstained. And then PW8, Lordship had seen, he did not notice, but then he saw him going out. And then the doctor, 2 injuries. Homicidal injuries, 1 below the chin and 1 below the Adam's apple. So there are 2 injuries. Although inquest says there are 1 injury, but then doctor said that there were 2 injuries. So these chain, this is well made out. There is no gap, there is no break. It is going on one after the other, the entire incident. I don't think so. Chain is not complete. This is my humble submission. But one, of course, the duty of the prosecution is to show who are the real aggressors, because here both parties got injured. And they were in the hospital, admitted, mother, sister. So who are the real aggressors? What is the genesis of the crime? This is the duty of the prosecution to establish. Now here I must say that the prosecution has not failed, because the prosecution had said, the police have stated, the doctor had said that the accused party were also there in the hospital with injuries. And there are no FIR from the accused side. FIR is lodged only by the complainant side. So from these evidence, we can show that genesis of the crime, who started the aggression, has to be the accused side. They could have otherwise given an FIR, but there is nothing on record that there was any FIR, cross FIR filed by the accused side. So as far as genesis, as far as who was the aggressor, is established by the prosecution. The prosecution has not failed in establishing. Otherwise, they would have hidden it. The people were there in the hospital. So in my humble submission, these facts do establish the case against all. Lordship was contemplating that common intention may not be there in case of other accused. But PW2, Lordship will see, when I went out, I saw all the 3 persons hitting my mother. Of course, there was a quarrel, and common intention takes place at the spur of the moment, even at the place of occurrence. They may not have intended long before. But here they have started, and they have started beating. And after fighting broke, I rushed there and they bit in my hand. So they were beating. So here is a case that common intention, of course, very difficult to show the common intention. It can be shown by the weapons carried, by the conduct of the parties after, before. Here it is difficult. Here nobody was carrying any weapon. And their conduct before and after the occurrence, before we are not aware, and after, of course, they were hitting whoever had come to save. So in a way, 323, of course, apart from the 2 injuries on the deceased, other injuries are not there. Lordship can come to PW6 once, the doctor. He said cut injury below the chin and cut injury below the neck. And bruises, position, size, none. So bruises were also not there. Mark of ligature not there. And let me come to the postmortem report instead of PW6. That Lordship will find at page number 70.
Yes, that
And the postmortem. And before that, Lordship will go to inquest report once. There it is said there was only 1 injury. Page number 67 of the inquest report, page number 67, Lordship can turn to. Their opinion of the witness and police about the cause of death and weapons of instrument used thereof, if any. 1 deep cut mark neck of the body caused by sharp weapons, and for which sense bleeding and death. Well, there is a mistake in translation. But here they say there is 1 injury. Page number 36, Lordship will see bruises and all bleeding from ear and mouth. In the inquest, page number 66, Lordship will see. I was just trying to find out whether there are any injuries before the actual cut given by Raju. Here, page number 65, 66, description of the injuries. Head okay, face okay, covered by bloodstain, of course there will be. In case of hanging, okay, no. Chest, stomach, limbs, right hand bend, slight bend, private parts, no injury mark. Other information about wounds, bruises, and marks of injuries, there it is written bleeding from ear and mouth. And other information, I don't think so. There are any other injuries. And then page number 67, it is said that there is 1 cut injury. Of course, below the Adam's apple and below the chin, he might not have been able to detect. Then Lordship will go to postmortem. Postmortem, he does not speak of any other injuries. Injuries position, page number 70. Cut injury below the chin, which is 6 inches length and 3.1/2 inches depth. Blood stained present. Cut injury below the Adam's apple, which is 5 inches length and 3 inches deep depth. Bruises, no bruise seen, no ligature seen, healthy. Trachea dissected, this is because of the cut. Vessels in the neck dissected because of the cut. Then cut injury on the neck, one below the chin and one below the Adam's apple. No fracture
That
seen, no.
injury is antemortem is not there.
And antemortem is there. Antemortem, I found it somewhere, Lordship. This
Bruises,
is.
bruises.
Bruises are not there. Bruises, had there been some bruises, then
No,
we
that
could have.
even bleeding on ear and mouth.
Hmm,
That was a result of an anti-mortem assault. That is not there.
hmm. Because the bleeding from the mouth and the
The
ear.
the cutting of the neck, that is anti-mortem.
Hmm.
But this bruises, we are on these three ladies.
Huh. Bruises, that bleeding from the mouth and the ear will not be as a result of cutting of the neck. I don't think so. That will be as a result of cutting of neck.
No,
Because-
it's not that.
Hmm.
You see, normally the bleeding time and coagulating time
Hmm.
would not be if the incident occurred half an hour
Hmm.
later.
Yes.
So it's not possible that the victim
Hmm.
would be bleeding for half an hour.
Hmm. Yes.
So therefore, looking at the coagulating time,
Hmm.
normally it will be less than a minute.
Hmm. Yes. And by the time the doctors would have put some bandages, something, those are also not there.
Those are not there.
So as far as three ladies or the Saju is concerned, her materials are less.
Medically, it's called BTN CT,
BTN city. BTN city, the full form.
bleeding time and coagulating time.
Acha, bleeding time and coagulating time. So these injuries, I don't know where it had come from, bleeding from ear and mouth, which of course doesn't take place in the, is not shown in the PM's report. But had that been due to the assault made by the families, there would have been some bandages. And
Bleeding from mouth is indicating of that when the carotid is cut,
yes,
then
chin,
the chin is cut, then maybe the blood will come into the,
yes,
also,
possible.
the
Hmm.
foot pipe and then.
And
coming out.
ear, that can also go to the ear, I'm not aware of,
I'm not aware.
can be. So as far as those three ladies and Saju, of course, overt act is there. He had bitten with a bucket, and that can be considered as an oral dying declaration.
This,
Of
I
the-
found somewhere that there's a injury in the finger of the bite injury,
Of this daughter.
daughter.
She said, but that he bit me, they bit me in my finger, but then no report. If it is there in the case diary, I have not seen, but not exhibited. But
But
such.
that is not also an offense. They are not charged with that offense.
Yes.
But there's some-
323.
you know, in the LCR, there is some document saying that the finger is having a bite mark.
But the charges, I'll see, Lordship will see the charges. 323, only for hitting the deceased,
Deceased, only that.
assaulted Anima Mehra. I did not talk about the daughter. So he was not charged of that. We cannot take that into
No.
account now. So it is only talking of Anima Mehra. So as far as these four, I'll leave it to your Lordship. I don't find much materials, but overt act, beating with a bucket, that can matter because it can be deduced as dying declaration of the deceased. That
That was not a proximal
No.
cause of death.
that was not a
It will
cause
never
of
come.
death. Yes,
will
Lordship
never
is
come.
correct. That was not a cause of death. Section 32 will not come. So in fact, evidence against the four are very limited. Right? Cannot punish on those. As far as Raju is concerned, these circumstances, along with the doctors and the dressers report, their deposition, I don't think so there can be any interference with that. But as I've said in the first half, if your Lordship can at all bring it down, because Grave and sudden provocation may not be sudden, it can also result from a series of events. Lordship knows there are so many judgments. Like a woman, she is tortured by her husband every day, and she that nurtured that ill feeling towards the husband, and one fine day she kills him, and that case was brought within the exception 1 of 300, grave and sudden provocation. And the Supreme Court says, by series of act also it can happen. Here may not be that sudden, but 1 hour difference. He came. He must have heard family is in the hospital with minor injuries or whatever. And then he comes and he gives the blow 2 times, but in the hospital. Difficult.
No, it's not clear. You want to travel which way?
Difficult. trying to bring it.
If you walk on the road, you're taking a path which is in the right in the middle of the road, and you are prone to accident from both sides.
Yes.
So take a stand, either be on the left or on the right.
Yes. What do I say? Like, it
Yeah,
can
young
come
men-
within, but no, not exception 4, only exception 1, grave and sudden provocation by series of acts.
But Mr. Sekia, you lose just because there is a judge in the court who does not watch who is coming in from the gate, who is
Those-
coming, who is going
no,
out.
Those arguments are, I don't think so, that will hold field
No, but
because
still,
uh,
he is losing a case just because a judge is not watching the gate, who is
Bec-
coming in,
mm.
and you not watch.
And the kind of investigation our state has. I mean, had it been some other state, okay, they could have get hold of someone who had seen him coming. But in our case, where investigation is always very bad.
No, I have spoken to a lot many people on investigations.
Mm.
It'll take some time for the state
Mm.
investigation to get up. Now there's a judgment of this court saying that the investigating officers should not be given law and order duty.
Mm. They
So
yes,
that has
that
been-
should be separated.
that is being implemented. Many things are happening because of the interference of the court at various levels. But so far as the state police administration and the home department is concerned, they feel that it will take some more time to get up everything, but it's in a,
Yes, developing.
we are
state.
satisfied with the development which is now being taken place.
And notifications have also come out recently, a notification issued by Honorable Chief
I'm aware of it.
Justice about that 41A notice, nobody should be arrested under 498. Those things are developing, so. But here, nobody had seen, of course, who will see, I mean, going out, there was already a hue and cry, somebody was killed. That way, Lordship is correct, then only people will see.
God will never agree. He will know.
Legal aid council ne.
Anytime you want, please. Pues ya no sé, no tengo ningún problema.
P Dwara. P Dwara.
My sister has found out
Lordship.
a gap in your middle path.
Mhm. If I may know what is that?
You want to know that? I think it would be better if if my sister addresses you, because she's the one who found out,
Mm.
let my sister interact and tell you what is the gap. Sister, you can tell her what is the gap. You just put it on. Just
There was no fight.
Acha.
They have stated that
Page
there was no
25.
fight.
page 25.
Huh.
Page 25, that is Raju
Huh,
Satnam.
there was no fight.
There was no fight.
I did not go
Go
to
to the
hospital.
hospital and kill him. That is
In
also
fact,
denied.
Raju was not there when the fight had
No,
taken
no,
place.
your 304 part 1,
Yes.
grave and sudden provocation.
Mhm.
So if there was no fight, then there was no occasion for him to be aggravated and go there and assault him. So your middle path of
Mm. Yes, first thing is that the other witnesses, let us see what other accused person, there was no fight. Everyone had
Yes,
said that. And that was an advice given by the advocate.
Same
No
answer.
fight.
Same answer.
Otherwise, you'll get entangled yourself. Oh, but then Beena said they started it and beat us up. Page number 37. This is again Genesis. They assaulted us and I sustained injuries. Debeswari also said.
That is also not in the record, that any injury report of the accused. That is also-
No, one of them said that they were in the hospital. Who
They
said?
were in the hospital.
Uh-huh,
Any injury or anything else?
There was a fight between parties. Both parties had simple cut injury and I treated them. This is in the doctor's
doctor-
evidence. Perhaps in the case diary, there will be some, but not exhibited. If I can see that this case diary, what kind of injuries that they had suffered. Only the case diary will do.
the case that you want.
In order to see whether any injuries sustained by the accused party.
That's not there. I did not notice.
Acha, acha. May not be
just
there. If
see,
your lordship
see.
had seen, I may not.
No, no, no. You just
need
go
not.
through it because
As per the doctor's deposition, my lord, there are injuries.
no, in the case diary.
Mhm.
You see, what happens is, Mr. Saike, why I'm saying no, without even going through the case diary, is that when it's a medical legal case, and then they are examined, then it becomes the duty of the doctors who are examining to record the injuries, if any. But if people are otherwise entered into they are entering into an hospital, there is no requirement of the police to make a pre-entry of injury in a medical legal case.
Hmm.
Therefore, it may not come into the case diary at all.
Anita kun.
Because if it comes in the case diary, I'll question it.
Hmm.
You see, there is no FIR from your side.
Hmm.
Then how can a document which is otherwise not relevant to the case diary
Why
find
would
entry
it be
there?
fixed? Yes.
So
Anita, of course, yes, simple injuries there, finger, as
In
your
the
lordship
finger,
had seen, bite mark.
That is the only thing I've found.
Yes, yes. Of
If
course,
it
lordship
comes-
is correct when there is no FIR from their side. Why will they seize those?
No, if it comes, then I'll question it.
Hmm.
Till the time it is not there, it is okay.
Then the genesis of the offense will again come, who are the aggressors and everything.
That is something we are not required to go into at this stage.
Hmm.
Okay.
Lordship.
This time we are not with you. Had Mr. P. J. Saigal and counsel for the appellant. There'll be a separate order. In this criminal appeal 158. Okay, then common order. For the appellants in both the appeal and this S. Jant and APP for the state. Next para. The proceedings of criminal appeal number 150 of 2017 is by the appellants who are aggrieved by the four appellants who are aggrieved by the judgment and order of conviction dated 27 to 2017 passed by the learned additional sessions judge Sivsagar
5 appeal.
in sessions case number 286 within bracket capital S dash capital S bracket close 13, thereby convicting the appellants for committing offense under section 323/34 IPC conviction from the section of this. For the other appellants.
323.
323/34.
No, but where is that?
Red with 34.
No, but
This
where is
is a
that?
paragraph 45,
Judgment.
page 60.
324,
323.
323/34 IPC. And sentencing them with rigorous imprisonment for 1 year and to pay fine of rupees 1,000 each with default stipulation. First of all, in the proceedings of criminal appeal 158 of 2017, the sole appellant therein has assailed the same judgment and order of conviction, thereby finding the appellant guilty of committing offense under section 302 IPC and sentencing him with life imprisonment and to pay a fine of rupees 30,000 with default stipulation. So the appellant was also convicted for committing offense under section 323 of the 34 IPC and sentenced to suffer rigorous imprisonment for 1 year and to pay a fine of rupees 1,000 with default stipulation. This is not very clear in the order. We'll have to read from page 45 to 50 to come to that conclusion. Next paragraph. The prosecution case was set rolling by one Sarumon, Sarumon, Mehra, Mehera, within bracket PW1, lodged before the officer in charge of Amguri Police Station on 18/7/2015. No, 5/9/2013. No, it's not good, it's okay. 18/7/2015. Is something wrong? How dates?
No, FIR was lost from,
This FIR is lodged in 2013.
Ah.
5/9/2013. Give the date 5/9/2013. Correct.
5/9/2013, yes,
Yes. Now in this
50.
page 3,
Hmm.
last there's a date of 18/7/15. How does this come?
That is 18/7/2015. This is later somewhere.
No, in the top in the page 1, it is okay. But why this signature here that
This is after 2 years. It was seen later. This is 2015 and the FIR is 2013.
just see the original one, you have the records.
Yes. FIR did lordship once.
Oh, FIR will go to this A file.
Ah.
I think there's a mistake. This 8/5/15 is a mistake. I didn't know that. They were informing that at about 6:30 AM on that day, his neighbors, i.e. the appellants, had quarreled with his mother, Srimati Anima ANIMA Mehra, MEHERA Mehra, near the water tap in front of their house at Factory Line. And that his sister Anita, ANITA, was also assaulted when she went to separate them. And in the meanwhile, Saju, SAJU, Satnami, SATNAMI, gave a blow on the head of his mother, as a result of which she sustained injury, and that she was admitted to hospital at Borbam, BORBAMT State. And that later, at about 7:30 a.m., Raju Satnami, RAJU, SATNAMI, appellant in Criminal Appeal 158 of 2017, had hacked his mother with a dao in front of nurse and doctor while his mother was undergoing treatment, and killing her on spot. Accordingly, Amguri PS case number 141 of 2013, under section 147, 148, 149, 325, 302 IPC was registered. Stop. After investigation, a charge sheet was submitted. And after committal proceedings, the case was transferred. The case was committed to the Court of Additional Sessions Judge Sivsagar for trial as Sessions case number 286 within bracket S-S public 2013. By order dated 17/1/2014, charges were framed against all the appellants under section 147, public 148, 149, 326 IPC, and that the appellant in Criminal Appeal 158 of 2017 was charged for committing offense to IPC. Question. नजर पे चाहते हैं हैं? Next part. In course of trial, the prosecution examined 10 PWs Vizlet VIZ. You copy it from page 63. 10 names. you write like this, Harimohan Mehra, then bracket PW1, like that, huh? And the following documents were exhibited. Ejahar, within bracket exhibit 1. Same, there are 5. So in the same page. Full stop. On conclusion of the recording of evidence of the prosecution witnesses, the appellants were examined under section 313 CRPC. Many were except for the appellant what is her name? Veena Devi.
Yes, Veena Satnami. Huh?
Veena Satnami.
Veena Satnami.
Except for the appellant Veena Satnami, who had stated that the informant side had started the quarrel. The other appellants took a plea of denial.
No, there is one more. Veena Satnami and they started Veena. And also Deveshwari. They
Yes.
assaulted us.
Deveshwari.
Huh.
Deveshwari Satnami.
And also Sumki Sarnami.
Huh?
No, Deveshwari ko sir, they assaulted us.
Deveshwari Satnami.
Yes.
Deveshwari Satnami. Huh? These two.
No fight.
Next para. No, even Chunki Satnami. Page 33. Just add there. Chunki Satnami. And declined to give defense evidence. Upon hearing the arguments of both sides, the learned additional sessions of Sibsagar by judgment and order of conviction dated 27/2/2017, convicted the appellants as referred hearing before. Next paragraph. Assuming the impugned judgment and order of conviction, the learned counsel for the appellants has submitted that the PW1, while giving his in his examination in chief, had stated that he had received a phone call from Shyam Paik, SHYAMPAIK, Chokidar, who told him that Raju Stami, appellant in criminal appeal 158 of 2017, had cut his mother with a dao in the hospital itself. But and despite the fact that in the FIR, there is a reference of the mother being assaulted in presence of nurse and doctor, the prosecution has utterly failed to examine Sri Shyam, the Shyam Paik or any nurse to prove the incident. Full stop. It was further submitted that the prosecution has utterly failed to prove murder being committed by Raju Satnami in the hospital because the prosecution had failed to prove to examine any witness who saw the appellant entering into the hospital. Full stop. It has been submitted that it was unbelievable that there were no independent witnesses available in the vicinity of the hospital who had seen the appellant Raju Satnami entering into the hospital with a dao. Full stop. It was also submitted that the evidence of PW8 was not believable because although he had deposed in his examination in chief that he saw the appellant Raju Satnami coming out of the hospital with a dao, but he had not noticed any blood stain in the said dao. And for the same reason, the evidence of the doctor within bracket PW4 who had seen the appellant Raju Satnami coming out of the hospital room with a blood-stained dao was not believable, as the respondent number 8 did not notice the blood stain. We'll reserve this judgment because
Another bench.
Yes.
My second bench. Argument controlling judgment is out. If you're giving those judgments, just mark the paragraphs.
oblige.
One below. One below. Judgment give one below.
The privilege of appearing in the Supreme Court. Well, what the Supreme Court did in the Sampurna Behuda matter, if I lordships permit me 10-minute capsule, I'll try and give a complete prospectus. Well, they laid down in para 94.
Just before that,
Yes,
just indicate, I am speaking for myself in the bench. You see, what is happening is, there's a lot of material here.
Yes, ma'am.
Now, to take an effort to read it ourselves and then to grasp the real issues which you have to adjudicate, I'm finding it some difficulty.
I have a
Because-
solution before your lordship starts. I
Huh.
prepared a table, my lords,
Okay,
and if a court master.
Yeah. because then
It will
it
give-
becomes easier.
Yes, my lord. I have lordships before that. I mean, before I take your lordships through this, my lords, I hope this will make it very convenient
Okay.
because I've laid down the directions, what has been put out and implemented in the various affidavits filed by the state and the various authorities, and what directions are required. Because I had, again, as I said, I was privy, my lords, to the webcast, and I understood what is falling from your lordships on that day, because what fell from the Chaudhary also was that if we could make suggestions and what needs to be done. My lords, I have tried to do that in a serial kind of a format. I'm sure it will help.
Okay, just before that, Mr. Nath, you filed an affidavit.
Well, I have received some instructions, Malad, I have already handed over copy to them yesterday.
Okay,
Lordship, they, as regard the position of the BWDC construction, Malad, that was an issue. And the number of cases pending, the POXO cases, trial, in which court, how many trials are pending, Malad, that information I have received, I have already shared. Malad.
okay. You have also done that.
That registry list I don't have, no, I have not received. The registry slip come.
Just share a copy with Mr. Sharma also so that he understands what we are referring to.
That.
Yes, Mr. Sharma.
Yes, ma'am. If your lordship sees, I mean, I'll not take your lordships through the judgment. What the Sampurna Behuda judgment, Justice Jaipur's order, it at para 94 gave about 16 directions with regard to the various aspects that were to be implemented. And at para 95, it spoke about child-friendly courts. For some reason, the High Court, when it initially took up the suo motu petition, my lords, it did not read para 94. It proceeded as though the direction was only para 95. And I'll read those paragraphs, my lords. It is well, that impression, sometimes one gets that impression, my lords, when an order is read. But the actual directions that were required to be implemented were primarily in para 94. So what I have done here, affidavits filed by the state also deal with para issues that were done as far as para 94 is concerned. But however, I have flagged certain issues and things that are required to be done in respect of those 16 directions. And I've compiled that in this chart. Besides that, in my writ petition, that is the Bachpan Bachao writ petition, I have also flagged about 6 issues which pertain to the implementation of the Child Rights Act. There are 3 basic acts, my lords, here. The Juvenile Justice Act, the POSCO Act, my lords, and the State Protection of Child Rights Act. My lords, if your lordship now turns to the chart, my lords, I have given the directions issued, my lords, what has already been done based on whatever affidavits have been filed, the relevant provisions of the act which mandate the state to carry out these obligations, and what are my suggestions as to what needs to be done. Now, the first thing, my lords, based on section 8, 17 and 18, my lords, the highest body as far as protection of child rights is concerned is the SCPCR. My lords, SCPCR should consist of 1 chairperson and 6 members. My lords, what has been seen based on the affidavits, my lords, that ACPCR has only 1 chairperson and 4 members which are vacant. Chairperson's post and 4 member positions are vacant. So, my lords, technically it is non-functional, and that is supposedly the highest body as far as the child rights issue is concerned. So therefore, my lords, a direction probably is mandated, my lords, that the state should endeavor that all the vacancies should be filled up. Similar directions have been given in various other states also, my lords. Another suggestion, this is not what the law mandates, my lords, but as a suggestion. My lords, as far as the JJBs and the CWC is concerned, there is the model rules, my lords. The model rule mandates, like in the High Court, if there is a vacancy, my lords, the vacancy should be earmarked and noticed 6 months in advance, so that by the time the incumbent retires, my lord, the vacancies can be filled up, my lord. A similar thing, my lords, can be read into the positions as far as the vacancies in SCPCR also is concerned, my lord. And that is my suggestion in 1.4. Now, my lords.
Yes.
Yes.
So Nath,
Lordship,
because of this question,
Lordship.
the state has a juvenile justice Assam rules of 1989.
My lord.
The Juvenile Justice Act is now the present act is the Juvenile Justice Year in Character. Is of the year.
May I assist, my lords?
Huh.
What they have done, my lords, and they have stated so in their affidavit, they say till the time we frame rules, we will adopt the model rules. They say that in their affidavit, my
Yes.
lords.
No,
Therefore,
that's the issue. You see, once there is a rule,
yes, my lord.
statutory rule, whether that can be kept in oblivion by adopting this model rules. That
Yes.
is the issue. Because
Absolutely, your lordship is absolutely right.
Mhm.
But for the time being, for the implementation, probably, my lords, what they have done, and they are mandated. The act mandated rules to be framed almost 5 years back, my lords. Even today, sadly, my lords, there are no rules as far as the state is concerned.
no, that's why because I have seen there's a rules of 1989.
Correct.
Now that would be grossly inadequate to in the present scenario.
Correct. And if your lordship sees my chart, that is the point in para 13. The lordship
Okay.
sees internal page 9 of this note that I handed out.
No. You're right.
Para 13, it lays out what they have stated in their affidavit also.
Because then, Mr. Nath, there has to be a judicial pronouncement to say that this Juvenile Justice Assam rules 1989 shall remain in oblivion, and will be the model rules which will have to be followed. But this will,
In fact, Malad, they are working on it.
no, it's, you see,
But
I'm not saying that the state is not working on it. That's not our suggestion. But what we are saying is that because once there is a rule in place, and this rules was framed in excess of the power under the erstwhile act, which is no longer there. So therefore, there's number one is there's a presumption that when the earlier act goes, the rule itself will not be in existence. That is the one.
Correct.
But you see, what happens is that under the savings clause, you save whatever action you have taken. So because of the saving act, we can't say that this rules is no longer there.
see,
So therefore, the only way out is to have a judicial pronouncement saying that since you have taken a stand, as Mr. Sharma says,
Gotcha.
in your affidavit, that it will be the model rules that you will be adopting. So there has to be a judicial, approval of that. Otherwise, the judicial side, we can't say that these rules are not there. Because the savings will save it.
Gotcha.
Yes,
because
that's what-
because the rule has not come, this situation has arose. Gotcha.
Well, Assam is not the only one. Malad, various big states also malad, have yet to frame the rules. Malad, so, malad, but
No, it's okay, but,
Yes.
but this is an eye opener, so far as your presentation is concerned, that if it's not there, we must have a judicial answer
absolutely,
to
absolutely.
this impasse.
Malad, I'm so grateful, Malad. In fact, this should be done across the states, Malad, because every state will have a saving clause. Malad, it didn't strike me before. Malad. I'm so grateful to your lordships for having pointed this out, actually. And your lordship is so right. May I come to the next point?
Yes, yes, please.
Well, direction two, NCPCR and SCPCR, bottom of page 1, Malaj, should take their duties and functions and responsibilities with great earnestness, keeping in mind the faith reposed in them.
Can you
But-
just refer to this SCPCR here in the act?
Yes, Malaj.
Yes,
Your lordships will see, Malaj, which section your lordship wants, 8.
No, this constitution of the state CPR, you said that it was mandated,
Mandated.
this SCPCR,
Yes, Malaj.
where is the provision here?
Malaj, which provision about Malaj?
Constitution of the SCPCR.
Constitution of-
SCPCR, very well.
It is under an.
Malaj, the lordship sees, I have in para 1.1, I have noted down the provisions. Section
8,
8,
17 and 18.
yes, Malaj. May I just read, Malaj? Section 8, first of all, Malaj. Malaj.
Because this is referable to board.
Yeah, to
Section
the
8.
board, Malaj. This is the functions of the commission.
Commission for
Yes, yes,
Protection of
I'm
Child Rights Act 2005. That is the act.
Huh?
Malaj,
Act-
lordship is referring to the JJ Act, I believe. It is CPCR, Malaj. That
Okay.
is the
Oh,
commission,
okay.
Commission for
Commission.
Protection of Child Rights.
Commission for Protection of
Commission
Child
for
Rights
Protection
Act
of Child Rights.
2005.
May I have a hand over a copy?
It will be here. Yes. Just because you'll have to,
Yes,
you'll be also requiring it.
yeah, I have a copy.
Oh, you have a copy. Okay. Yes, please. Good, I'm sorry, I have a-
I can hand over my copy also.
No, it's
Malaj.
okay. You just go ahead.
Vacation of office by chairman or members. Lordship has that?
Please,
Justice Surana has
please
it?
continue. Yes, please continue. I'll catch it.
Oh, very well.
Ah.
If the chairman, you have a soft copy of that?
It's okay. Please don't bother.
Yes, ma'am.
I'll get it in a minute.
If the chair, I'll read it slowly, Malaj.
Uh-huh.
If the chairperson or as the case may be, a member, A, becomes subject to any disqualification mentioned in 7 or tenders his resignation under subclause 2 of section 5, his seat shall thereupon become vacant. If a casual vacancy occurs in the office of the chairperson or member, whether by reason of his death, resignation, or otherwise, such vacancies shall be filled within a period of 90 days by making fresh appointment in accordance with the provisions of section 4, and the person so appointed shall hold office for the remainder of the term of office of so and so, so and so. Malats, coming to section 4, Malats, section 4 now deals with appointment of chairperson and members. The central government, I'm so sorry, Malad, I should have added section 4 also. Central government shall by notification appoint the chairperson and other members, provided that the chairperson shall be appointed on the recommendation of a 3-member selection committee constituted by the central government under the chairmanship of the minister in charge of so and so, so and so, so and so. Malad, this is for the national body, Malad, technically, for basically the NCPCR. Malad, a similar provision is
Section 17.
section 17, Malad, as far as the state is concerned. That is the State Commission for Protection of Child Rights. A state commission, Lordship has 17.
Yes, I have it.
A state government may constitute a body to be known as Dash, Commission for Protection of Child Rights, to exercise the powers conferred upon and perform the functions assigned to a state commission under this chapter. The state commission shall consist of the following members, namely a chairperson, who is a person of eminence, has done outstanding work for the promotion of welfare of children, and 6 members, out of which at least 2 shall be women, from the following fields to be appointed by the state government, from amongst person of eminence, ability, integrity, and standing and experience in education, child, 1, education, 2, healthcare, child health, care, welfare, or child development, 3, juvenile justice or care of neglected or marginalized children or children with disabilities, 4, elimination of child labor or children in distress, 5, child psychology or sociology and laws relating to children. 3, the headquarters of the state commission shall be at such place as the state commission may specify. 18 relates to the appointment. The state government shall by notification appoint the chairperson and other members, provided that the chairperson shall be appointed on the recommendation of a 3-member selection committee constituted by the state government under the chairmanship of the minister in charge of the department dealing with children. So, my lords, 1 plus 6. Today we have just 2, and that too the members.
Chairman retired in the month of May.
Already
The
done.
chairperson has retired in the month of May, my lord. And some members also retired.
It should.
Correct.
Lordship.
At 1.4.
Yes.
That.
I'm so
Im-
pleased.
im-
Should be start.
Immediately.
The process should start, my lords,
Process.
and there is no harm in that. my lords.
Lordship.
So, progressive kind of a suggestion, my lords,
Correct, correct.
this always can be done.
Yes.
Now coming to the second direction.
You can add if the government wants to extend their position, they may not do that exercise within previous 6 months.
Yes.
The
No, not that.
process is going on, my lord.
No, it's okay.
there are-
I'm just suggesting.
Lordship.
For future,
For
his
future.
suggestion is for future also.
Hmm.
That there can be a
Yes.
mandamus saying that it should be started
Correct.
6 months.
6 months
prior
in advance.
In view of that, it is a very essential and necessary.
Correct.
Correct. Well, that is exactly my while reading through, Malad, if the JJBs and the CWC mandate such a rule, why should that not be made implied, Malad, in section 17 and 18? That's the apex body. If JJBs and the CWC can have it, why should it not be for the state commission? Malad, direction 2. 94.2 and 94.6. Well, this is pertaining basically that every year, Manoj, there has to be an annual report. Now, what is the object of the annual report? Annual report, Malad, gives the various statistics and analysis of what has been done, how many cases has been filed, what is this thing, whether the child has been rehabilitated, not had rehabilitated, what is the outcome of all that. So it is basically a mirror on the face of the government and various authorities with respect to implementation of the child rights laws, Malad. Now, what has been stated by the state, Malad, that the reports, the annual report for the years, Malad, 2021, 2020, 2021, 21, 22, and 22, 23 has not been filed, Malad. The only report, Malad, that emanates out of the various affidavits is of the year 1920. So the last 3 years, Malad, there is no audit or there is no annual report. So therefore, Malad, what I see,
Tell me, what does this report contain?
Malad, this report, Malad, annual reports contain, Malad, your lordships will see if the court master can give the judgment of the orphanage, Justice Lokur's order 2017, 7 SCC. 2017, 7 SCC. You have a copy of that? Malad, I have it in my iPad, Malad. Shall I hand it over, Malad?
No, we have it.
Okay. Great. Malad, lordships can search it.
2017,
Yes, 7 SCC,
7 SCC,
578.
578.
A bench of 2, Malad, exploitation of children in orphanages.
Yes,
In
yes,
the- Lordship has that.
yes.
Lordships will go to, Malad, para 100. Para 100 first, Malad. And then I'm come to 100 and para 108. For the directions, for the purposes of ensuring the implementation of the JJ Act.
Yeah, just a moment.
I'm so sorry.
There's a reference to technology and computers.
Yes, before that, Malad, para 100. Social audit, lordship sees in bold. Para 100.
Social audit, yes.
Yes, Malad. Malad, para 100 is what I read, Malad.
Yes.
For the purposes of ensuring that the implementation of the JJ Act is proceeding in the right direction, it is necessary that a social audit be conducted every year. Social audit gives reasons for introspection as well as improvement in the services. Social audit has gained relevance as a tool of public accountability. It has been defined as an assessment of the department's non-financial objectives through a systematic and regular monitoring on the basis of the views of its stakeholders. A social audit is considered novel, as it's supposed to serve as a supplement to the conventional government audit, often done in 12-month circles, generating an audit report every time. In fact, the report of the task group on social audit by the Office of the Controller CAG, it was opined that such social audit be brought into the mainstream of auditing by the Indian Audit and Accounts Department as an essential process and tool in all the performance audits of social sector programs, as they afford an opportunity to strengthen the micro level scrutiny of the programs, program planning, implementation and monitoring. The requirement of social audit is necessary not only for the purpose of introspection, but also transparency and accountability in the effective implementation of the
I'll just
JJ.
stop you for a moment
Yes,
here. You see, this, as per the directions of the Supreme Court of India,
Yes, ma'am.
there's a format which has been created for monthly reporting and annual reporting.
Correct.
That the High Court is doing it.
Right.
So is the state required to do some?
This is required by the state, Malad. The High Court deals with only one couple of other issues like JJ Act, etc. There are several other issues like the CCIs, the organizations where the childs are kept, Malad, after recovery. So an audit has to be done across all the provisions of the 3 Acts.
Okay,
That is not being done, Malad, as far as the state is concerned.
because so far as the High Court reporting is concerned, to
Correct.
the Supreme Court.
Correct.
In fact, last week, we launched a what you call a link in our website.
Correct.
From our website, now you can access the data of the juvenile justice cases,
Correct.
POXO cases which are pending before the court for adjudication
Correct.
under the jurisdiction of this court, you will now find in web.
That's very innovative, very good. That brings a lot of transparency also. Manoj.
So this is something
This is something,
this
this,
did not come to our notice.
correct. So this responsibility and Malaj's onus is on the state government to do. There's a separate requirement as far as the Supreme Court guidelines for the court to do. That is primarily on the JJB courts, Malaj. But this is overall, Malaj, overall implementation of the child rights, what has been done, what are the steps required, a detailed audit, Malaj. All other quite a substantial states are doing this, Malaj. And the results of that are just phenomenal, Malaj. Lordship also sees now, Malaj, para 108. 108.8 Manoj.
Directions.
Yes, Manoj. I'm so sorry, Manoj. This
Nothing is wrong.
actually pertains to the filling up of vacancies, Manoj. So your Lordship will only read that, Manoj.
Hmm.
Now, Manoj, Lordship just sees para 2.A2. As per the RTI reply dated, Lordship has that my chart, Manoj.
Oh,
Back to
okay.
the chart.
Just.
Talks about filling of vacancies. Well,
Yeah,
I'm
in fact,
grateful.
appreciating your chart.
No, I'm so
But
grateful.
This is what is what was actually required, because we find it difficult to
Yes.
to
Collate
reach this grasp
everything.
it and then to address
Yes,
the issues. We are finding it difficult, but
Correct.
this is simplified it.
yes, sir. I'm so grateful, Malad. I'm so grateful to my learned friend. The orphanage's judgment in para 108.8 casts that obligation of the annual report on the state commission. I'm so grateful, Malad, not on the commission should make these annual reports. And the government is to do the social audit. There are two different things, Malad. There is one, the annual report by the commission, Malad, as per 108, and a social audit separately to be done by the government. There are two different aspects. I'm grateful. And Malad's Lordships, Malad, my suggestion also is that the state government should lay this before the legislature, Malad, so file it in this court. So this will also bring in more accountability as far as these reports are concerned, Malad. Now coming to B, as far
Because
as
this what is to be laid out in the house of the state legislature
yes,
is basically the government's prerogative. The
But
by
yes.
judicial order,
correct. I see
how
that.
far we can
Yes,
drive
yes.
the legislature to.
I see that. That becomes an issue of policy or whatever, Malad, but that's their prerogative, the executive prerogative. I see that. Now, Malad,
We may only give a suggestion, but
Yes.
it is ultimately the legislature who
correct,
will dictate what it wants to read.
correct. Malad, Lordship sees 2B at the bottom of the page.
Yes, yes.
Now, section 13 details of the various functions of the NCPCR and the SCPCR, Malad. And what I'm trying to say here, Malad, is that we do not have any status report as to the functioning of the SCPCR. Malad, what it is doing, etc. Malad. So therefore, the annual report, if they file it, Malad, will also Malad do an audit of all these aspects that are there in the act, Malad. Now, para 3. Para 3, there is substantial compliance, Malad. So therefore, nothing is required insofar as para 3 is concerned. It is, can be deemed to have been implemented, my lords, by the state government. My lords, then comes the vacancies. There was a direction in para 95.4 regarding filling up of the vacancies in the JJBs and the CWCs. What I am told, my lords, is 4.2. If your lordship sees 4.2, as per the information available at SCPCS Assam, we have calculated from it from the website, 14 posts are vacant in the CWC, and we do not have any information available with regard to the JJBs, my lords. So the directions that I have suggested, my lords, is that all vacancies should be immediately filled up in a time-bound manner, keeping in view, my lords, Rule 88. The DCPO should notify the state government about any vacancy in the board or the committee 6 months before such vacancy arises as mandated under Rule 88, my lords, and 85. State government maintains a panel of eligible persons to be appointed as members of the committee as per so-and-so, and all necessary infrastructure shall be provided to the JJBs and the CWC within 3 months. In fact, a lot of the JJBs and the CWC, my lords, were not able to function in the states of Karnataka and Telangana, my lords, and the high courts there by writ has ensured that all the facilities for functioning, my lords, computers, ACs, whatever is required, my lords, have been, my lords, provided to these JJBs, and the positions are complete there. Now, my lords, para 5. Yes. Plus, direction 5 is regards to, my lords, pertains to the various sittings. I'm sure your lordship is taking that up on the. Sorry. Yes. 5, my lords, pertains to the sitting of the JJBs, my lords, and the CWCs. My lords, on the JJBs, my lords, I'm sure your lordship has taken several initiatives on the administrative side, and nothing much needs to be done. But what the Act mandates is that the proceedings under the JJB, my lords, should complete within a period of 4 months, my lords. My lords, there are various considerations, so sometimes it cannot happen, but that is what the Act mandates. My lords, so I have given certain suggestions if these directions can be in some way, my lords, be issued. My lords, para 5.3, that section 14.2, which mandates that it should be done within 4 months, should be implemented. 2, CWC comply with Rule 22 and submit quarterly reports, my lord. This also will bring in transparency.
Because we have been apprised that if the proceedings are pending for more than 6 months,
Yes, ma'am.
then they are being acquitted.
So therefore, it's important, my lords.
Oh, you made that note, pendency of cases more than 6 months.
Yes,
Right.
I put in that also.
Uh-huh.
We got it from the website also, my lord.
Mhm.
And we also made our RTI. Based on that, we have got these information.
But Mr. Nath, now you'll have to give a pinpointed reply to this.
Correct.
All these points
But
raised.
this note will help tremendously help us because the record is voluminous. As regarding 95.4, we have some reply, possibly this has not come here. But page 314, we have replied in our affidavit. The boards have been already constituted in all districts.
What you can do is,
Logic.
because this is not an adversarial.
Absolutely.
situation.
Correct.
So he has given pinpoint wise that this is the
Correct.
issue, this
Logic.
has been done, this is not.
Not been done.
And this is the role of government and what government should
Should
do with his suggestions.
Correct.
So better you should, if you can respond to
Now-
this note,
Now,
then
to
it
this
will be easier for us to issue
Correct.
direction.
And lot of directions, the
Correct,
lordships will be
Correct.
not required to be passing so many directions. my lord.
Ah,
no, logic.
in the meantime, something may be implemented.
I'm sure, my lord, I'm sure.
And in fact, this note will make the things clear for the authorities also, so that
That's right.
they can visualize where the things are to be need to be done.
No, because
Logic.
that's why we appreciated this, but in fact,
Absolutely.
going through this and this is makes a,
So I've compiled it in about 11 pages. my
Yes,
lord.
yes.
Ah.
And I'm grateful to my colleague here, my lord, who done the hard work based on my suggestions.
Logic. Even my files are also voluminous, but if it is very difficult to find out things. No, this will help.
Here it's specific that this
Correct.
section mandates this,
Correct.
judgment mandate this is the
Yes.
state of affair.
Yes,
I will have to say that this is the reason or we are doing this or implementing
Yes,
this.
yes.
May have something that yes, we have accepted this suggestion that we'll do it prior to 6 months or we may get an. That may come from your end.
Logic.
just give an overview
Yes, my lord.
of this.
Yes, my lord. Thereafter, my lords, your lordship sees. My lords, I was with. Para 5, my lords, I have given these details. It's coming to 6. 6 has been complied with, therefore no technical directions are required, my lords. Now, my lords, use of technology, lordship had seen that. Again, all I say, my lord, directions be issued to respondent number 2, file an affidavit within 1 month from today, whether database. Now, my lord, this is again a very interesting thing, especially concerning the Northeast, my lord. I don't know what is happening as far as the other states where this high court is not. My lord, a lot of people from the Northeast are taken away, my lords, and they don't return. Now, when a child is taken away, it should be brought back, my lords. So, websites should be created, etc. I will put in a detailed note separately, my lord, specifically of missing children, because this is a very important issue. Whether the child, after having been recovered, my lords, in suppose a child is taken from Delhi and is found by the police authorities in Delhi, my lords. Sorry, from here and is found in Delhi. Whether the child has been returned.
There's one more issue which has cropped up
Yes.
that day. The authorities are in a fix whether it would be appropriate for them to flag the issue because of the judgment of Justice Puttaswamy's case. Now you see what is happening is, let us say that a street child, I'm using the term,
Yes, my lord.
that we suddenly he's detained and the police wants. The authorities had a discussion last week. We had a JJ workshop, one day consultative, what do you call it, on last Saturday, one day consultation. There he said that, well, we see a child and we want to create a database so that we have their fingerprints and irises, and then therefore what happens is that if this child is a missing child from say Kerala,
Mhm.
he's identified and restored back.
Correct.
Now just the data exchange, the data recording for other purposes is banned under the Justice Puttaswamy's
Correct.
case. So you said that that also is a reason why we are not been able to identify, because these people we are finding them. We don't have a database of them. And now we can't create a database because of certain things. Now.
From my mind, my lords, to my recollection, there is a direction by the Supreme Court in one of the judgments to create such a website. I will get that judgment. So if that is there, my lords, so probably that will have precedence even over Puttaswamy. I know it's 9, but my lords, on this particular aspect, as far as a specific point, my lords, in my respectful submission, my lords, it might be an exception.
Okay.
So I will try and find out.
But they are now onto it, because the Director General of Police himself made a statement
Correct.
that they are seriously wanting to do something about this missing children.
Correct. That is exactly the direction, my lords. This was the direction of Justice Lokur in para 95.8. And if I read that specific paragraph, my lords, I think a lot of clarity will come, my lords. He has detailed out the various aspects of it, my lords, in this judgment itself. If I'm not wrong. Use of technology. Para 77, that is the 2019-18 4 SCC, my lords. My lords, I have it attached to my writ petition at page, what page? In fact, this is the order that I was talking of, my lord. This itself covers it. The Sampurna Vyavhara judgment. Suo motu petition mein kaun sa paragraph? Page kaun sa? Well, in the suo motu petition, your lordship, you'll find
Order sheet separate. Good.
page 46 minutes of the suo motu petition. Let me read it from there. Well, it's para 79. The SEC citation is different slightly, Malad.
46.
Page 46 of the suo motu.
Oh, suo motu.
Yes. Internal page 42. Lordship has that.
Yes, no.
Yes.
Twenty 7 SCC,
7 SCC,
594.
594.
This is the petition.
Yes, Malad. In my
PL 60.
yes, Malad. It will be there, Malad. Lordship has found that.
Yes, I have found.
Okay.
Annexally.
That will be the SCC version, Malad. Then your Lordships will find that, Malad's page of the judgment 472, para 77.
In the given case.
The use of technology, para 77, placitum B, Malad. In a given case,
What page is it? Page? No, page.
472 of the SCC, Malad. SCC page 472 of that particular SCC. 2018 4 SCC, page 472. I'm so sorry, Malad. The next time I'll make a convenience compilation.
No,
also.
it's okay. Things are there, but
Yes,
it's
Malad.
the three files we have to.
Yes. I'll make a convenience
No, it's
compilation.
okay, not prepared. Yes,
Lordship has
para
77. Malad, that 472 internal page of the
Yes.
SCC.
So SCC, it alters the position. Now this is the leading judgment, so it starts from para 48. This, it starts from 48, then it will come to para 1. This is something I have flagged to many people.
Yes, Malad.
The SCC reporting, if you see, it starts from page para 48.
Correct. Oh, well, I have the SCC version, the web version, which starts at para 77, this particular portion.
No, no,
Here
no.
it's page 40.
The first page of this order,
Oh, first page of the order,
it starts from para 48. So what SCC does
right?
it alters the position of the judgment, original
Oh,
judgment.
yes. Well, I'll tell you why. This is because of the ECB judgment, Malad, of Supreme Court.
No,
Based
it
on,
merely says that that it has a copyright over the
correct, head notes.
head notes.
Head notes, Malad.
But that doesn't give them right to change the.
And it
alternate-
also says of the para numbering. It says what the Supreme Court judgment says in the ECB judgment, Malad. It says the copyright vests with the footnotes, the head notes, the editorial comments that is there, and the para numbering. So to get that copyright, they have what they suddenly do, Malad, they change the copyright. They break the para sometimes from the original text of the Supreme Court uploaded order, Malad. So
And it doesn't match because the earlier 108 paragraph
correct.
in Supreme today it is 56 or 57.
Oh, okay.
So the original judgment contains only 60 paragraphs.
60.
Supreme today people, they say that they used to maintain the paragraph as per the Supreme Court order.
Yes, I found it.
Lots.
But this is a question I put and they have demonstrated that it is as
Correct.
per the Supreme Court
Yes,
judgment. They have
Correct.
showed it to
This
us.
this is specifically to create the copyright.
Ah.
They are trying to Malad, take advantage of the judgment because the judgment did not give them any benefit otherwise.
Ah.
Because at that point of time, judgment today in scale were eating into the space
Ah.
at that point of time. So that is the reason. So
Now we have programs which have come up, which is AI based.
right.
So you don't have to search,
Oh,
you have to just question them.
okay.
comes out with an
Vo-
answer.
Voice command, Malad.
No, voice command or even if you want to type it, by way
Uh-huh.
of question, you can type it.
Oh, is it? Oh, okay.
You don't have to now ask a specific query,
Okay.
limiting it to say Sampurna Behura, then you say
Oh.
missing children,
Okay.
then it comes out. No, you ask any judgment on missing children, it will show us.
This is on the dashboard that the Supreme Court is
No,
created.
no,
is-
No, it's the Supreme today
AI.
AI version.
Oh,
Supreme
acha,
today
acha,
has
acha.
come up with
Oh,
the
I'm
AI
not aware,
version.
Malad. I'm not aware.
I
of
am
that.
using it.
Okay.
I'm also using it.
Okay, I am not aware, Malad. I'll
Ah.
have it checked up, Malad. Quite interesting, actually.
So you don't have to make a specific query.
Right.
Like, for example, I did not understand what is the eco-sensitive zone.
Uh-huh.
So I just gave a query, what is the eco-sensitive zone? And it flagged the answer in such a manner that within 5 minutes in the courtroom, I was more aware than.
Okay.
Then you can get from there.
Yes, okay, it's quite interesting.
So,
But Delhi somehow, Malad, none of the lawyers that I see uses this, Malad, Supreme today. But I'll have a look immediately on this.
and so this,
Earlier, I also did not like the
Yes.
original version.
Uh-huh. So this
But
is a very
now the
interesting,
AI is
correct.
far better than.
here in the courtroom, I have issues with this net.
Uh-huh.
Anything can be asked.
Anything can be.
Anything can be asked.
Means
Even I can ask how many judgments, please list the judgments of Justice A.D. Chaudhary.
Okay,
We will
acha.
list all.
All the judgments. Oh, interesting, very interesting. Okay, so it will pick it up like that.
huh,
Very interesting.
it's not opening. Once it opens, I'll show it to you.
Yes, yeah.
It's an AI version, so therefore this chat GPT and all they use it
Okay.
and then
Uh-huh.
they create that
Oh, very interesting.
answer where they highlight the entire paragraph so that you can find it out if it is to your need. It's okay. Otherwise, you go to the second judgment and then check it
Right.
out.
In fact, Manoj, AI, I personally feel it's a very dangerous tool. I
Very
mean, to
dangerous.
such extent, it helps the human, it is fine, Malaj. Beyond that, Malaj, it will all eliminate all human effort or human, Malaj, thinking in a big way. Malaj, in fact, my
No, Mr.
on the
Sharma,
lighter
I
side,
would say otherwise. It would lead the supposing any counsel who is arguing, or senior counsel is arguing. Now he must be sure that what is the judgment all about, because if he goes by the AI and gives a citation.
correct. No, I'm saying from a different perspective, Malaj, in terms of the legal profession as such. In fact, on the lighter side, Malaj, my son is doing law, and before he did law, I had just written a paper on artificial intelligence in the legal profession, Malaj. After I read that, Malaj, I told him, you are not supposed to give the law entrance exam because his prime will be about 15 years hence, Manoj. in the legal profession. Obviously, everybody takes about 10 years. At that point of time, the need for lawyers will be just 1/10 of what it is today. Because almost all Malot's work as far as drafting, etc. is concerned, will be taken over by AI.
It is.
Yes, Malot.
This,
It
I've
is
seen
already
this-
doing, Malot.
No, I've seen that.
Forget
I,
about this lawyer, other job.
Yes, Malot, it is
no, no,
dangerous.
I've seen that, I'll tell you. I've seen this same Supreme today has come up with a AI based, they are developing it, AI based program. And I just took a 3 or 4 because of the positive time. First thing I did was ask them to draft a habeas corpus petition.
Okay.
Habeas corpus petition drafting took about 1.5 minutes.
Oh my goodness.
And then the second night said that, okay, 138 notice. 50,000 rupees, 138 notice. A drafting came by about 30 seconds.
My goodness. Just imagine.
Then some improvement in that notice. That let it be a detailed notice. Detailed notice came again in half a second. Half a minute.
Correct.
Detailed notice means the earlier paragraph was only 2 paragraph. We owe you so much and give it. Now it gives a detail.
What is more dangerous is the fact that probably about 4 or 5 years hence, Malad, before a litigation is filed, we know which bench it is going to go to. So the AI will predict the judgment. So when a client comes to me, he will also have access to that, Malad. So he will verify and he'll say, let me settle it out. What's the point of going to court and getting an order against? So that is the danger.
But this is
That is the danger.
This is happening.
So therefore, litigation per se also, Malad, will come down. The number of lawyers required will also come down, Malad. It is only the niche areas that will survive. That is what my, therefore, Malad.
No, no, I don't see that.
Yeah, let's hope not, Malad. But I will share the article, Malad. It's an interesting read.
Para 17 in a given case,
Yes, Malad.
failure to be
Yes.
maintain basic minimum standards, so and so.
Yes. Malad's para 79, Malad. In the context of use of technology, MWCD must be, Lordship has that paragraph?
No, it's not there.
Para 79, use of technology is
79 here in the SEC copy,
SCC, Malad.
exploitation of children in orphanages.
No, the Sampurna Bihura. I'm so sorry, Malad.
Oh, acha.
In the Sampurna Bihura, Malad.
Okay. This is, I'll have to get it.
Well, it is there part of the compilation. I think Justice Chaudhary has that. It is part of my compilation as well as page 46, Malad, of the sumo petition.
Six. Yes.
Lordship has that now? Of the sumo petition, Malad. May I hand over my copy, Malad? I have it here. handy.
Because we'll need it. So once we, page number,
46, internal page 46 of the said petition, Malad. EIL 1 of 2018.
just give you a copy then.
Yes,
Yeah, I'm
Malad,
not
I will,
finding it.
I will.
2017, 7 SEC 594.
Yes, Malad. No.
18 4 SSC 433.
PIL Sumoto 1, Malad.
Annexer B.
Yeah. Achha, theek hai. Oh, yes, it is there. Oh, okay, I'll share it with my brother.
Yes,
Okay, please continue.
Yes, my lord. Para 77, lords.
Hmm.
First of all,
Yes. I'm clear, sorry. Yes, yes.
The submissions made by.
yes, my lord.
Ha,
The submissions made, not, this is the finding actually.
yes,
The
yes.
use of technology, lordship has that, use of technologies.
Yes, yes.
Yes.
Huh.
Subpara 4.
Must be, my lord. Yes, subpara 4.
Hmm.
The use of technology both by JGBs as well as CWCs is extremely important, and we are disheartened to note from the affidavits and submissions made by the MWCD that there is an acute shortage of computers and peripherals with the JJBs and the CWC. Technology is important, so and so, so and so. Now, technology is important not only for effective functioning of the JGBs and the CWC, but also to deal with issues that would arise from time to time concerning tracing and trafficking of missing children. That is exactly what I was saying. Children who leave the childcare institutions, victims of child sexual
Mr.
abuse.
Nath, this paragraph you can share it with your DGP. You refer him with conversation he was having with me
Gotcha.
with regard to the tracing out of the child.
Mal-
And just show him this paragraph.
Yes, yes.
Because he was very anxious. He was wanting to do something, but he was apprehensive of that use of this technology,
Mhm.
so that it might influence that
Gotcha.
judgment of the Supreme Court. Huh?
So this is a clear mandate, Manoj, that
No,
technology.
thank you,
should
because
be-
this will help you.
Yes.
They want to do it.
Yes. This will go a long way, I feel.
We just refer to the conversation I was having with him on this tracing out of the
Missing.
profiling of the children who are
Missing.
who may be missing.
Gotcha.
Because he's right, otherwise Mr. Sharma is right. If a child is trafficked and then after 10 years, he may not know from where he was there, from where he became. But if he can be profiled, then perhaps he can be tracked.
In fact, I got a case while dealing with a petition, criminal petition. She was taken from her residence to another place as a maid, a child. She was raped, she became pregnant. She was dropped in her original village according to her, but she knows nobody.
Nothing.
Nobody.
And then this CW, somebody picked her up, then an affair was filed in that place. She was 15 years, she was with that family where she was there. And she is not aware of her own village.
Own village.
Very sad stories, Manoj, especially when it's children. It's
Mhm.
Mr. Sharma, due to time constraints,
yes, I understand, Manoj. I think
we
we
will
can,
just summarize this and say that this is to be responded to by
Yes,
the.
that will be, and then if they, whatever, based on that, whatever is not complied with, Manoj, that then your lordships can pass directions.
Yes.
Very well.
Gotcha.
Please correct me. When do you next want to have it?
Malad, I'm here on the 19th. This is a matter which is pro bono, Malad. So if your lordships can keep it on the 19th, there is another matter. I can come in for that. Or Malads, join your lordships on any date. Malad's convenient. Through the video conferencing. Malads.
19 can be.
Can be.
no
Very
issues with that.
19, 3:30 is most convenient.
It could be by 9. This will have priority.
I'm so grateful.
Gotcha. By 19, in the meantime, I'll also get some time. Let's go. That's all.
Yes.
Register. PP Sharma Ranjan. Senior counsel.
Well, that's not yet, well, that's
Yeah,
council.
only counsel, okay.
Council is
Okay.
good enough.
Mr. Learned counsel for the petitioner. As well as Mr. D. Nath Learned, senior government advocate appearing for the state. Next one. The learned counsel for the petitioner has submitted that although much stress is given by the state for implementation of directions contained in paragraph 95 of the case of Sampurna Behura, you'll get that. What is the full name? Sampurna Behura
Sampurna
versus State
Behura
of
versus Union of India.
Union of
for
India.
2017 4 SCC.
18
18 4 SCC.
18 4 SCC
433.
4
33.
33.
32
433.
33.
Lot.
So however, in order to comply with the directions contained therein, comma, the state would also have to comply with the directions contained in paragraph 94 thereof, 94 and 96 thereof.
Yes,
Correct?
yes. 94 primarily, my lord.
Is it 90?
95 is regarding the child-friendly course.
Okay, 94. 94 of the said judgment. Full stop. For the effective implementation of the judgment in, for the in this of the said judgment, comma. The learned counsel for the petitioner has prepared a compilation of 11 pages, wherein the appropriate provisions of the Commission for Protection of Child Rights Act 2005 and Juvenile Justice Care and Protection of Children within bracket close Act 2015 have been quoted.
Also POSCO, my lord,
Huh?
2012 Act. The Prevention of Children from
POXO.
And also POXO Act have been quoted. Full stop. Next, the learned
Yeah.
counsel for the petitioner has also highlighted that the Assam State Commission for Protection of Child Rights within bracket ACPCR for short.
They call it ASCPCR, Assam State.
Assam State, AS. Assam State, okay, AS. ASCPCR for short. Requires appointment of a chairperson and 4 members. Full stop. It is submitted that as per instructions received by him, comma, the chairperson of the ASCPCR has superannuated in the month of April, May 2023, and that the all 4 member positions are vacant.
By this time, some.
No, it's okay.
retired.
I'm
Lot.
just recording his
Lot.
statement.
Not all 4, my lord, 4.
Acha, four.
There are
four.
six.
Six.
Two
Acha, out of six, four member positions are vacant. Accordingly, it is submitted that with the lack of appropriate quorum of the said commission, there is every likelihood that the functioning, that the said commission is not functioning in its full force and vigor. It is also submitted that the ASCPCR is required to conduct a social audit and regarding the functioning of the various
To effectively monitor and ensure implementation of various laws regarding.
to for effective monitoring and implementation of various laws related to the protection of child. First of all, it is submitted, he submits that as per information received by him, comma, the state commission has not done the social audit. And even if such audits have been done, comma, they are not put up in the website in the public domain. And therefore, therefore he has not been able to find out if the deficiencies in the implementation of the child protection laws have been overcome by now. Full stop. In this regard, the learned counsel for the petitioner has suggested that if the state can initiate the process of filling of vacancies in the ASCPCR at least 6 months prior to the an incumbent would be demitting office, comma, the ASCPCR would be in a position to function without any impediment, without any because of lack of quorum, appropriate quorum. Full stop. It is submitted that the Supreme Court of India in the case of Sampurna Behura, this was Sampurna Behura that
Yes, ma'am.
in Sampurna Behura that
Yes, that is the judge.
that
2018-4.
the social audits should normally be
Oh,
done
no,
annually.
No, Malad, that
No.
is the Tamil Nadu orphanage case, 2017, 7 SCC.
In Tamil Nadu orphanage case,
Yes,
From
I'll give the
2000
citation to the court master.
2017,
7 SCC, 578.
570, that the social audit of the child welfare institutions be annually done and placed in the public domain for effective implementation of the child protection laws. So hence it is submitted that the directions of the Supreme Court of India in the said case is also required to be followed by the state of Assam. Anything more you want to highlight?
Well, it's a couple of things.
No implementation is required already implemented. So some expectation will implement as highlighted government to respond to this.
Moreover, comma, the next para, moreover, comma, the learned counsel for the petitioner, comma, in his note has highlighted about the status of implementation of the various directions contained in the judgment of Sampurna Behura within bracket Supra. Full stop. In this regard, the court is of the considered opinion that the state government should respond to the various aspects highlighted by the learned counsel for the petitioner in his note filed today. Full stop. The response in form of an affidavit shall be filed within, if it is on 19th, it can be filed within 18th,
Lordship.
within 18th.
By-
If it's on the 17th, Malad, then when I come on the 18th or 19th, Malad, I can come prepared.
No, we'll say that we will file, within 15th.
15th.
Lordship,
Within,
before 2 days, before 2-3 days. Lordship, fine.
within 15th or 16th of September.
Very.
16th is Saturday is a working day.
It's a working day.
15th or 16th of September 2023. With a service copy mailed to the email to the learned counsel for the petitioner. Next paragraph. List again on 19/9/2023. Yes,
Lordship,
If your lordship permits me, and if it's not impinging on your lordships. What happens as a result, what I have seen, whenever this chart is given, a lot of the paragraphs are not commented upon. Here, I have put in certain places where no implementation is required. Dehorse that, if my learned friend can comment on the 21 paras that I have given, if wherever the implementation is there, no comment is required. So lordships will direct that the government will come and make their comment or suggestions on each of the 21 paragraphs that I have stated here. So that,
no, we are not going to give the paragraphs.
yes, very well, the entirety, your lordship has already said that.
Entirety.
So if
we are
my
not
learned friend
limiting
gives
it.
that,
sometimes.
Just that,
Lordship,
but we take note of the submission.
Yeah.
I'll take care of that.
No, in
Sometimes,
certain paragraphs, he has said that it has been implemented.
yes.
yeah, I have seen.
There you
I
don't
have
have to respond.
I have seen.
Ah.
But sometimes it happens because it is not the same authority who is implementing all the things. Because of the various departments, in one affidavit, the other person says that, no, I am not the
That's why
authority.
That's
If
exactly.
required,
in adjudication.
No,
Only
do
ask
you,
again.
do you want separate affidavits to be filed? Is
But
that,
Because the implementing authorities are different.
you want to file separate?
If
affidavit?
required, we'll file.
Okay.
Ultimately, we'll
Okay,
respond to the
just,
query.
Prior to that, you say,
Lordship.
at this juncture, the learned senior government advocate has submitted that that the implementing authorities is not a single window implementation.
Correct.
No, the implementation window is not by a single authority. And therefore, he seeks leave to file additional affidavits by respective authorities who are to implement various
Lordship,
points which has been raised in this
In this
note.
it is not, Lordship.
Full stop. Liberty is granted.
Lordship.
And my learned friend will collate all of that, and then give me one chart because it will become convenient. If that is not
Right.
possible, I will do that exercise.
No, I'll do that.
Very, I'm
Because
so
in the-
grateful.
Because in the form of affidavit, I have to file. The police cannot say what the social welfare department will say.
No, correct.
I
Taking
have
your
some-
point.
Lordship.
Just add one more thing. The learned senior government advocate may also, if separate affidavits are filed, the learned senior government advocate may also also make a
Consolidated summary.
summarize chart
Summary chart.
of the contents of the affidavit for just.
Yes, that is.
Lot.
just charge.
Lot.
But then it is easy. We know
Yes.
this, we know that, and
Correct.
it's easier.
Malad. At least
And that
we'll-
is,
we'll do that.
If separate affidavits are
Reference.
filed, on the basis of that, you can reply to his
Correct,
paragraphs
correct,
in a note.
correct.
That is good.
That will be your.
Referring to the
that will be your note.
Yes, yes,
That will be your
yes.
He can add one more column to my chart. I'll give him the soft copy also. Manoj.
You give him.
I'm the soft copy. I'll give him this. It'll be easier for him.
Easier.
no, we are not concerned whether it is easier for him or not. It must be easier for us.
Yes, yes.
I'll do it.
I'm so grateful, Manoj. It's always a pleasure, Manoj. Always a pleasure. I'm grateful.
Chart produce, made a part of the code. It could not be you. You have to just sign it and give it to us because
Very
we are, since we are keeping it,
I will. do that.
it has to be. এটা করবো দুটা করে দোকানে একটু আমার শেষে তাতেও লাগবে we just adjourn the matter to the next date. This matter, we'll adjourn this matter to 19. Assam Private School. No, I will not fix it on 19th is the only day we are taking off. But 19th also nothing will happen. Since this will take some time. But this bench is not a regular bench.
It's a special bench.
Due to both sides are present, due to positive time matter could not be taken up today.
I think what is the
5 o'clock we can't say. Based on 9/2023. This is the private school. What has happened? In fact, what is the
Yes.
stand you are trying to take? What is this stand you are trying to take?
They are challenging a particular
300, I remember
One
that.
second.
300 more students, but that is something which is what you call, it will be unconstitutional. You are creating what you call division based on the number of students.
category one, they're earning more though. That's why it will be different. They are small school
No,
and bigger
Education
schools.
is not unlimited. Ask them.
Education can't be trade.
That will.
Education can't be trade. We
then-
can
then-
understand.
Then they have not, they'll have to collect the fees.
Hmm?
Then they will cannot collect the fees.
These are fees
No, you
is
see,
not for profit making. You see every private school. I think TMA Pi Foundation, it cannot be profit making. Therefore, these are all trust and profit is.
profit is incidental.
in-
You see, now let me ask a simple question. Can anybody in this court stand up and say that, well, I will educate my child in a school which does not have all the facilities? Can anybody stand up and say today that he'll be imparting what you call education to a child who is in a school which has no facilities, number one. So if a school has a facility, then you say that the school has a facility and therefore it is a rich school. And therefore you tax him more.
The other facilities also given.
No.
No. Whether it's trade or business. These are trust. In fact, in their trust, if you go some judgments, they cannot have any provision of profit. Even if there are surplus, they can use in some assist and help some educational institutes. These fees are only for running the colleges. What they are earning, that is a different issue, but it cannot be a trade.
That's
Subject to what you
on
argue.
19.
If education is a trade, then you'll have to come up with a notice, the state will have to come up with a notification that if it is a trade,
Alright.
then the what you call government teachers will be free to do the trade.
So on it, 19 million.
Because then you are saying the government doctors will not be able to practice, the government teachers will not be able to give a private tuition. Because you see, I come from a background of Don Bosco school. They may be earning, but it is because of their school that we have got a good education. Then I don't say that my second education was in Commerce College, it's a government college. But still it was a good college and I gained my education there. So,
We'll address the
so
situation, my lord, that how,
irrespective of whether the government institution, if the government institution itself is like IIT, it's a government institution, but it is excellent. It's a what you call institution of excellence.
Collection of fees will not necessarily mean that it's strict.
So collection of fees itself, my brother is right. It can't be a trade. But then you are taxing students who in schools who are having 300 plus more.
we'll address it, my lord. On 19 million.
Because then you are acting as if just like what you call it's income tax. Well, it's not a trade. It's not a what you call trade license fees. Now you are taxing as if it's a. Huh. Because then what happens? You know, in this court, there is a recorded case. The income tax authorities raided a lawyer based on the old people will know. Based on the cost listing in the cause list, saying that you have this income and therefore we are deeming income. Correct. And that was done. It's a case which is there in the annals. So therefore, there also we said the same thing. High Court said the same thing. It's not a profession, is not a trade, and therefore, even subsequently there was a effort to impose trade license on the lawyers. Then came the writ petition, and the writ petition said that lawyering is not a trade, and therefore you can't do it. Therefore, lawyer, you don't have a trade license.
No, even GMC Act, my lord, let's say that particular class one, their lawyers have to take trade license.
No, but there's a stay of this court operating.
No, my lord, when I joined the GMC as a Chief Council, I came to know that this has been challenged. And there is a stay order. Later on, that case has been not been represented. This is for default.
I don't know, but you see, now let us take that example. Assuming that you want to tax a lawyer, can you do it on the basis of a trade license fee, on the basis of income of the lawyer? You are creating a what you call what is it called? Intelligence.
Then it will be a double taxing.
No. Intelligence.
Intelligible differential.
Intelligent difference, yeah. It's not that. Because then you see, you are taxing on the basis of income, which you can't do otherwise. It's an exclusive domain of the central government to tax on the basis of income.
And they do that, my lord, as far as GST is concerned, although it is a reverse, my lord, collection, where the client has to pay for whatever I bill, my lord, they will deduct and pay me. My lord, but they have to deposit. It's their responsibility to deduct, my lord.
That's service tax.
That is service tax.
That's service tax.
Yes.
No, but that's not based on income.
That is not based on income. That's on accrual basis.
Actual basis. So therefore, this is something which needs to be whatever so rectified by the GMC. Ultimately, it's a school.
Grateful.